Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2 this morning. We have 3 dockets. We have our announcement docket, pretrial conference docket, and the trial docket. When I call your name, please come forward with your attorney. If your attorney is not here, we'll wait for your attorney to arrive because your attorney may be in another court handling another matter. If you are not represented by an attorney, when I call your name, please come before the court by yourself. Alejandro Hernandez. Okay, very good. Good morning. Mr. Hernandez, your full name is Alejandro Hernandez?
Yes, sir.
How are you doing, Mr. Hernandez? I'm doing fine. Thanks for asking. Mr. Hernandez, representing your case by your attorney, Mike Jamal. Mr. Jamal, how are you doing? That's good. And the state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you?
I'm great, Judge. How are you?
I'm doing fine. That's good. Now, Mr. Jamal, what is your announcement in Mr. Hernandez case?
We're asking for one more resetting. We've had a long discussion this morning, and we'll either dispose of the case or the next case we'll have to set on from.
That's correct, Your Honor.
Okay, give us a reset date, announcement. Okay, this case will be reset to June 2nd.
I'll be in drug court.
Okay.
Thank you, Your Honor.
Okay, this case will be reset to June 9th, 2025. Mr. Jamal, you're gonna get your reset. Once you get your reset, you're free to go and you have a blessed day.
Thank you.
You're welcome. What docket is that? Oh, so soon. Yes, I'm looking for your case.
He's on the bridge.
Yeah, no, that's what I'm looking for. Okay, Jose Jesus Deleon. Yes. Okay, Mr. Deleon, your full name is Jose Jesus Deleon?
Yes, sir.
How you doing, Mr. Deleon?
Yeah,
I'm doing fine, thanks for asking, Mr. Deleon. You're represented by your attorney Trinidad Zamora. Mr. Zamora, how are you doing?
well, sir, thank you.
That's good. And the state is represented in this case by attorney Shane Hilton. Attorney Hilton, how are you doing?
I'm good, Your Honor. Thank you.
You are. And Mr. Zamora, what is your announcement in Mr. Deleon's case?
Defense is ready. We had a motion to suppress set the last time we were here.
Right.
Yeah, I don't know what the state's at. We're ready to rock and roll. I just need to find out the time that match staff that I didn't know that it has to go back to Houston. So I
Okay. Okay.
Your Honor, the state would be requesting a reset for the motion to suppress. I think there was the mix up on the e-file. The addresses for the state were wrong. I didn't get notice. I saw today that it was in the court's file. I never got a copy of the motion to suppress until today.
Oh,
And we're checking with Mr. Zamora's staff. It was sent to we discovered that it was sent to the wrong email address. It was sent to the jeffco.tx, the old email address, instead of our new Jefferson County.
okay. But I know I received it.
Yes, Your Honor. I did notice this morning that it was in the court's file. And
Yeah.
but I didn't have any warning on that.
So you,
I apologize to the court. You'd ask for a reset.
okay. Okay, so so the motion was timely filed. The state just haven't he said he had the wrong email address or something, he said?
Yes, Your Honor.
and transition between the emails.
Right, I understand. So the state is, entitled to have notice. I think it was just maybe just a mix up in terms of, because they did do a update on emails for some reason, but. So what the court is, now, let me ask you this here. He's coming from out of town.
Yes, Your Honor, and I apologize to Mr.
Okay.
Moore for that too.
Non-factor, I mean, I'm here for.
Right. I was just wondering, if we can set a date that's convenient, with your schedule. Okay? Because we thought that we was gonna have it today. Give us some dates. And we probably, huh?
When Ada is here.
Yes,
June 2nd and June 9th, Ada.
those are not good. Now, the week, what about that, during that week, because we have it that whole week,
Yeah, we have a week.
yeah. Hold on, let's find out from here.
June 9th. June 9th is right.
Yes, what we're gonna do, we want to do it the week of June 9th, because in the hearing, it's gonna take up some time. And so I'm thinking we might want to do it on what about a Thursday or a Friday of that week? Of the week of June 9th.
12th is fine.
What's the 12th? Okay.
Thursday is Wilson, right? Well,
And what's that, and what we're gonna do, we're gonna do it in the afternoon. Okay,
get here, we don't have to go, come here at.
no, don't come in now, we're gonna do it at 1:00,
No, but.
right? So we'll have all of that afternoon,
1:30, June 12th.
1:00.
1 o'clock.
Yeah, 1:30 is better for you,
No, 1:00.
because, okay. Let's do it at 1:00. Okay, you can get your reset, Mr. Trinidad, and Mr. Deleon, you're gonna get your reset. You'll be free to go, and you'll be free to go as well.
Thank you, guys.
And you're welcome.
No, wait.
Mr. Schillings, you can take your mic off of mute. Mr. Schillings, you can take your mic off of mute. Is he moving?
I think he's frozen, Judge.
Oh.
Stroke.
Oh,
I hope he
yeah,
doesn't.
it's frozen.
It's the worst.
Okay.
I just
Now,
assumed,
Mr. Schillings, is represented, oh, there he is. Mr. Schillings, you can take your mic off of mute. Okay. Yes, Mr. Schillings is represented in his case by Attorney James Macon. And Mr. Macon, how are you doing?
I'm doing wonderful, Your Honor. Thank you for asking.
That's good. Mr. Schillings' case is set on the court's announcement docket. And what is your announcement in Mr. Schillings' case?
Your Honor, if we could have a short reset, I believe Mr. Schilling's case will be in plea. My co-counsel in this case, Mr. Trecker, couldn't be here today.
Okay,
He'll be here at the next set.
okay, give us a reset. It's on the announcement docket, page 5, the first case. Okay, this case will be reset to June 9th of 2025. Mr. Schillings, you'll get your reset from your attorney. You're free to go. Stay in contact with your attorney. Your bondsman, your case is reset to June 9th, 2025. And on that date, you need to be here in court in person. You're free to go. And Mr. Macon, let's see.
I have Mr. Satderfield, Your Honor. He's working
Hold on.
up along the Canadian border.
Okay, this is cause number 25 CCCR 0706, case of style of state of Texas versus Adam Wade Satderfield. Mr. Satderfield, is he appearing via Zoom? Mr.
Yes, sir.
Mr. Satderfield,
Yes, sir. Froze up, sir.
Okay, how are you doing, Mr. Satderfield?
I'm good, sir. And you?
I'm doing fine, thanks for asking, Mr. Satderfield. You're represented in your case by your attorney. Attorney, James Macon. Do you have any bond conditions in this case? Hold on a minute. Could you check and see if we have bond conditions in this case? Okay, reach me the bond conditions. Now, Mr. Macon, what is your announcement in Mr. Satterfield's case?
You know, he's currently working out of town along the Canadian border, and asked this be reset to the same day as June 9th. And I believe we'll have a resolution of the case.
Okay. June 9th. Okay, this case will be reset to June 9th, 2025 at 9 a.m. Now, Mr. Satterfield, you need to be in court on that date. Mr. Satterfield, before you leave, I need to give you some bond conditions. So
Okay.
that you have a DWI second, which is a offense, it's a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. Now, the standard bond condition states as follows: following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing of drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 does not apply. However, condition number 4 does apply. Condition number 4 states that the defendant shall the defendant whose information charges any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the device if ethyl alcohol is detected in the breath of operator, and said device shall be installed at the defendant's expense, with written verification of such installation being submitted to the court on or before 3 days after today. Do you understand that condition?
Yes, sir, I do.
Okay, and
Yes, sir.
condition number 5 states that the defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device, mobile breath device. Any violation will be grounds for revocation. Do you understand that condition?
Yes, sir, I do.
And condition number 6, defendant must attend AANA meetings 3 times a week and provide proof to the court. Do you understand that condition?
I do.
Now, these bond conditions will be given to your attorney. When he leaves, he, I guess, can send them to you. And every time that you come into court, you need to provide proof to the court that you have been attending the AANA meetings, and you need to send proof of the interlock device to your attorney so that he can, we can put it in the court's files.
I'm not operating no vehicles at this time, Your Honor.
Okay, any vehicle that you own or operate, okay?
I don't.
All right.
Yes, sir.
All right. Now, Mr. Macon, this case will be reset till June 9th of 2025 at 9 a.m. You'll get a copy of these bond conditions. Once you get a copy of the bond conditions and you reset, Mr. Macon, I think this is the last case.
It is, Your Honor.
You'll be free to go,
Thank you.
and you have a blessed day. Thank
You
you.
too.
Thank you. Here you go. Yeah, well, yeah.
That was except for Cassandra Owens. We finally figured out how to get in veterans court.
Okay, Cassandra Owens. Miss Owens, your full name is Cassandra Owens? Yes, sir. How are you doing, Miss Owens? I'm doing fine, thanks for asking. Miss Owens, you're represented in the case by your attorney, Attorney Giles Cole. Attorney Cole, how are you doing?
Great, Judge. How about yourself?
I'm doing fine, thanks for asking. Mr. Cole, what's your announcement in Miss Owens' case?
Your Honor, we finally, we're gonna apply for her to get into the pretrial diversion program and offer to the military. Veterans court.
Okay, have you applied?
No, we just figured out how to get there.
We had a brief discussion with Ashley earlier, and I was waiting on that to refer to Mr. Cole. So now that he has all the information, he's gonna go ahead and send a letter to Ms. Molfino.
Okay, give us a reset date. Just reset it in June, yeah. Okay, this case will be reset to June 16th, 2025. To give you attorney an opportunity to submit an application for the Veterans Court. Ms. Owens, you're gonna get your reset from our court coordinator. Once you get your reset, you'll be free to go. And you have a blessed day. And Mr. Cole, is this your last case, only case?
Yes, it is, Your Honor.
Okay, Mr. Cole, you're free to go and you have a blessed day. Juan Azakor, oh, that's a plea? Okay, just have a seat, okay. Call it when it's ready. Yes,
Good morning. My name is Leslie Boy. I'm an attorney here from Charles Johnson's office this morning. We're here on Ramona Houston.
what document?
Announcement docket.
Just say her last name is Houston.
Houston,
Okay, Ramona Houston. And what's your name again?
Leslie, Leslie, last name is Foy, Foy.
Okay, Ramona Elaine Houston. Miss Houston, your full name is Ramona Elaine Houston.
Yes, sir.
How are you doing, Miss Houston?
I'm good.
I'm doing fine, thanks for asking, Miss Houston. The attorney of record is Charles Johnson. Attorney Johnson is not here. However, Attorney Leslie Foy is here, standing on behalf of Mr. Johnson. Does Ms. Foy have your permission to stand in for Mr. Johnson?
Yes, sir.
Okay, now, Ms. Foy, how are you doing?
Okay, how are you?
I'm doing fine, thanks for asking. Ms. Foy, what is your announcement in Ms. Houston's case?
Judge, we're not ready. This is a misdemeanor that is out of the same incident as a felony next door. We just announced over there this morning, the judge gave us 30 days to figure out what's going on. This is a case that somehow the felony file got lost for a while. And so it looks like it's 5 years old, but we've really only been working on it since November. I don't know what happened. And so we're close to a resolution and
Yeah,
I
I was
think. it
looking
will
at the
work.
date. Okay, give us a reset date. Well, no, let me make sure, say, when is the felony case
They
reset?
didn't tell me that. They said they will email me electronically what the next date is. I
Okay,
think what we're normally doing is getting that one and then calling and
Right.
asking y'all to set
Yeah,
it.
we were supposed to go through this one.
okay, so what we'll do is we'll have our court coordinator to continue to check the computer. And once we get a date, will reset this case on the same date of the felony.
Thank you, Judge.
Now, on that day, you will do like you did today. You come here, check in with our court bailiff, and then you'll go to the felony court. And then once you go to the felony court and dispose of that case or finish in that court, then you come here and let us know. All right, so you're gonna get your reset. You're free to go, Ms. Ford, and you have a blessed day. And Ms. Houston, you have a blessed day as well.
Thank you, Judge.
You're welcome.
Your Honor, may I approach? I have a plea ready.
Okay, is it ready? Do we have it ready? Okay.
In this case.
Oh, that last name,
Ma'am?
the last name.
I got it. That's all right. He's on top of it.
Okay.
We knew you were gonna struggle with it. Not your fault. Thank you.
Is this Mr. Green?
No, this is Mr. Harper, Your Honor. Darian Harper.
There's no icons on there, so I have to shut it down and turn it back on. Oh. They're doing, it's an update on this thing. No better than those. This is cause number 24 CCCR 2312. Case is style, the state of Texas versus Deleon J. Harper. Mr. Harper, is that your full name?
Yes, sir.
Mr. Harper, would you please raise your right hand? Mr. Harper, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Harper, you may put your hand down. How are you doing, Mr. Harper? I'm doing fine, thanks for asking. Now, Mr. Harper, you're represented in your case by your attorney, Attorney James Paget. Attorney Paget, how are you doing?
Doing good. Good morning, Your Honor.
Good morning. And Mr. Paget, the state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge. Thank you.
Good. And Mr. Paget, do you waive a record in Mr. Harper's case?
Yes, Your Honor.
Mr. Harper, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Deleon J. Harper, on or about August 25th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest. Mr. Harper, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Harper, how do you plead guilty, not guilty, or no contest?
No contact.
Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yeah.
Wait for this statement. What's that? Wait for it. Yes. Don't you think you gotta close that? Yeah, now I'm trying to. I just. John, on there. No, it's something, yeah. You gotta press the button down on the thing anyways. That's what they said. Oh, I'm gonna try to see it again. Mine is currently locked. You did it? Okay, here we go. Okay, now, Mr. Harper, I have before me a document that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document? Okay, on page 2 of this same document, there's a set of initials DH on the line next to a box. There's check no continuing, which means no contest. Did you place your initials on this document?
Yes.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes.
And on the next document, there's titled trial court certification of the defendant's right of appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
This. I also have before me on paper a document that is titled discovery certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Mr. Harper, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
Did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Harper, are you a citizen of the United States?
Yes.
Stanford State's one.
Any
No
objections?
objections to stage 1, Your Honor.
No objection. State's Exhibit number 1 will be admitted. And Mr. Paget, you've advised and counseled Mr. Harper. Is there any evidence that he is currently mentally incompetent to stand trial?
None, Your Honor.
Mr. Harper, your attorney has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Harper, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is to 1 year deferred probation with a $300 fine and 50 hours community service.
Okay. What is the court cost?
Offer 277.
Okay, Mr. Harper, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $136 a month. Will you be able to pay the $136 each month?
Yes.
You'll also be required to perform 50 hours of community service, and you'll be required to adhere to the other standard terms and conditions of this probation. Mr. Harper, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
Yeah.
And do you accept the state's offer?
Yes, I do.
Mr. Harper, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Harper, if you successfully complete this probationary period, this case will be dismissed. It would not appear on your record as conviction, and you may qualify for a non-disclosure. Mr. Harper, this will conclude your case, and just for the record, if you interested in information on the non-disclosure, you can talk to your attorney, Mr. Padgett, because he's quite competent in those matters. Okay?
Yes.
And Mr. Bailey, please have a, just please have a seat and wait for the bailiff to come back, and then you'll follow her direction. You can sit on the chair on the wall. Caleb Green.
He's right outside. I'll get him, Your Honor.
I see.
She's right outside, Your Honor. She's was helping.
Okay.
Who might have been.
Jefferson County Court at Law number 2 is in session in 2 cases, cause numbers 24 CCCR 1274 and cause number 24 CCCR 0832. Both cases are styled the state of Texas versus Caleb Deshaun Green. Mr. Green, is that your full name?
Yes.
Mr. Green, would you please raise your right hand? Mr. Green, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Green, you may put your hand down. How are you doing, Mr. Green? I'm doing fine, thanks for asking. Mr. Green, you're represented in your case by your attorney, Attorney James Padgett. And Attorney Padgett, do you waive a record in Mr. Green's cases?
Yes, sure.
Mr. Greens, in cause number 24 CCTR 1274, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Green, it alleges that you, Caleb Green, on or about February 13th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of harassment. Mr. Green, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest? Now, you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charge? Apparently, the thing is in between boxes, it's supposed to be on, it's a Class B. So, yeah, well, you just gotta have to press the button and erase it.
With that arrow.
There's a button on there that you can press and erase?
I got it. Okay, so I explained to you Class B, but the arrow I checked was in between them. Okay, so I'm gonna check Class B. Right? Nothing changed about what I explained to you. Sorry about that, Chairman.
Okay. Now,
I'm having trouble getting it.
okay. Now, Mr. Green, do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials. Uh-oh,
Got to get some bugs out, huh?
yeah. On page 2 of the same document, there's a set of initials on a line next to a box that's checked, no contingent, which means no contest. Did you place your initials on this document?
Yeah.
On the next page, page 3, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled trial court certification, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes.
I also have a document on paper that is titled discovery certification. Do you recognize this document? And is this your signature on the line that's titled defendant? Mr. Green, before you sign and initial all of these documents that I just showed, did your attorney go over these documents with you? And did you understand everything that he went over? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Green, are you a citizen of the United States?
Everett State's one.
Any objections? States Exhibit number 1. Mr. Paget, any objections? States Exhibit number 1.
None, Your Honor.
Okay, no objections. States Exhibit number 1 will be admitted. Mr. Paget, you advised and counseled Mr. Green, is there any evidence that he is currently mentally incompetent to stand trial?
None, Your Honor.
And Mr. Green, your attorney, Mr. Paget, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Green, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is the 2 years deferred with a $750 fine, 80 hours community service, and the requirements of the defendant have no contact with the complaining witness, Zeno. And the companion case will be dismissed for the plea of.
Okay. What's the court cost?
Which one?
It's right up below the other guy, 277. Okay. Mr. Green, the state is offering that you serve 2 years deferred adjudicated probation. During the 2-year probationary period, you'll be required to pay a fine of $750 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $124 a month. Will you be able to pay the $124 each month?
Yes, sir.
You'll also be required to perform 80 hours of community service. You cannot have any contact with the victim, in this case, Janae Tizino or Tizino, and you will be required to adhere to the other standard terms and conditions of this probation. The state will also be dismissing clause number 24 CCCR 0832. Mr. Green, do you understand the state's offer? Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer? Mr. Green, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Green, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record. You may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. You can stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go. And you have a blessed day.
And I have 2 cases on Zoom, Your Honor.
Okay.
I think they're Miss Simmons cases. Thank you, Mr. Huber.
Okay.
Yeah. Both on your announcement.
Okay, this thing here.
I can't comment on
It just,
it.
yeah,
I managed to get through it.
he had locked out on me.
I had a little trouble with racing for a little while. But I got it.
Okay. Now you have,
Gary Kennedy and Nadia Rubin. Rubin. Both on Zoom, Your Honor. Both should be on the announcement. Right. Hey, can I look at your hall? You have offers.
no, it shut down on me. I have to. Let me see. This is Kennedy. Okay, both of them. Okay, this is cause number 24 CCCR 2942. Case is styled the state of Texas versus Sherry Kennedy. Ms. Kennedy is appearing via Zoom. Ms. Kennedy, you can take your mic off of mute. How are you doing, Ms. Kennedy?
I'm doing well, and yourself?
I'm doing fine. Thanks for asking. Ms. Kennedy, you're represented in your case by your attorney James Paget. And Mr. Paget, what is your announcement in Ms. Kennedy's case?
Your Honor, we have received discovery. I just need to review the discovery with her. If you will give us 30 days. I have an offer from Ms. Simmons now, and I will contact my client and review with her.
Okay, give us a reset date.
Which document?
It's on the announcement docket, page 5. Okay, this case will be reset to June 9th, 2025 at 9 a.m. Ms. Kennedy, stay in contact with your attorney and your bondsman. You're free to go and you have a blessed day.
Thank you.
Okay. Nadia Rubin. Nadia Joe Rubin. Nadia Joe Rubin. Would you, yes, your Nadia Joe
She
Rubin.
should be on Zoom. She said she was on Zoom waiting.
Nadia Joe Rubin. The iPhone, I don't know who that person on Zoom that has iPhone, would you please just state your name?
Stephen Campbell.
Okay, that's somebody else. All right, you can take your mic off. You can put your mic back on mute.
Okay, Your Honor, so, she said she's on Zoom. Let me step to the back, Your Honor, and, I can help her.
Oh, we don't
Thank
have
you.
room now. Okay, I can't, just turn the computer back on. Okay, this next case is cause number M 333-482, case of style of the state of Texas versus Walton James Everett III. Mr. Everett, would you please come forward? Mr. Everett, your full name is Walton James Everett III.
Yes, sir.
How you doing, Mr. Everett?
All right, how you doing?
I'm doing fine, thanks for asking. Mr. Everett, you're represented in your case by your attorney, Attorney James Jansen, Attorney Jansen Bailey, who is appearing via Zoom. Mr. Bailey, how are you doing?
Doing well, Your Honor.
And Mr. Bailey, what's your announcement in Mr. Everett's case?
We're ready, Your Honor.
State?
State's ready.
Okay, now, Mr. Bailey, we see you here this afternoon at 1:30 for trial. And Mr. Everett, you'll be back at 1:30.
All right.
All right.
Thank you, Judge.
All right. We have Mr. Wenders.
Your Honor, if we get approached real quick on one other matter on the trial docket, Mr. Roebuck's case, Malone.
Cole Wayland Malone. This is cause number 23 CCCR 1240. Case of style of state of Texas versus Cole Wayland Malone. Mr. Malone, is that your full name?
Yes, sir.
How are you doing, Mr. Malone?
Good, how about yourself?
I'm doing fine, thanks for asking. Mr. Malone, you're representing your case by your attorney Tom Roebuck. Attorney Roebuck, how are you doing?
I'm good, Your Honor. Thanks for asking. How are you?
I'm doing fine, thanks for asking. Mr. Roebuck, what's your announcement in Mr. Malone's case?
We have an agreement, Your Honor, to reduce this to Class C.
That's correct, Your Honor. So we would need, time to complete that reduction in,
How much time do we need?
couple weeks' time, figured.
What, 2 weeks will be enough, or
I believe so, Your Honor, with that.
that'll be enough, 2 weeks? Okay, give us a reset date.
May 19th.
May 19th. Okay, Mr. Malone, this case will be reset to May 19th, 2025. Stay in contact with your attorney. Now, the JP, if the case is disposed of, the JP case, if you dispose of that, I think the state will dismiss it before this date and you won't have to come here. But if it's not taken care of by that date, then you have to be here.
Yes, sir.
All right, so you're gonna get your reset. Once you get your reset, you'll be free to go. And you have a blessed day, Mr. Mr. Roebuck. Is this your only case?
Yes.
All right, you're free to go as well once you get your reset, and you have a blessed day.
Thank you, Your Honor.
Thanks.
You're welcome. Let's see, this is. It's not even ready. Okay. Jacoby Holland.
No.
Court is in session and cause number 25 CCCR 0052. Case is styled the state of Texas versus Jacoby T. Holland. Mr. Holland, is that your full name?
Yes, sir.
Mr. Holland, would you please raise your right hand? Mr. Holland, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Holland, you may put your hand down. How are you doing, Mr. Holland? I'm doing fine, thanks for asking. Mr. Holland, you're represented in your case by your attorney, Attorney Laura Perazo. Attorney Perazo, how are you doing?
I'm doing well, thank you.
That's good. And Ms. Perazo, do you waive a record in Mr. Holland's case?
Yes.
Mr. Holland, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jacoby T. Holland, on or about November 24th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Holland, do you understand what you have been charged with? And to this charge, Mr. Holland, how do you plead? Guilty, not guilty, or no contest?
No.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Holland, I also have before me on my computer a document that is titled misdemeanor plea admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of the same document. Okay, on page 2 of the same document, there's a set of initials on the line next to the box that's checked no Kendrick, which means no contest. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
And Mr. Holland, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Holland, are you a citizen of the United States?
Yes, sir.
State Officer States one.
Any objections?
No objection.
No objections. State's Exhibit Number 1 will be admitted. Ms. Perazo, you've advised and counseled Mr. Holland. Is there any evidence that he is currently mentally incompetent to stand trial? And Mr. Holland, your attorney, Ms. Perazo, has advised and counseled you. Are you satisfied with her representation? Has she provided full, effective, and competent legal representation.
Yes.
Mr. Holland, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers are freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering a $300 fine plus court cost, and there is a 1-day credit of Jefferson County Jail to be accredited towards that fine and court cost.
Okay, what's the court cost? So it's, you say it's 587? So the court cost must be 287. Okay. All right. Okay, Mr. Holland, the state is offering that you pay a fine of $300 plus court costs of $287. It comes to a total of $587. You will be given credit for the 1 day that you spent in jail, which will reduce the court costs, which will reduce your fine and court costs by $100. So your total amount of fine and court costs, instead of being $587, is $487. Are you able to pay the $487 today? Okay, now, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes.
Okay, Mr. Holland, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Holland, you will stand at the end of that table, follow the directions of the bailiff. Once you finish following her directions, you can go downstairs and make the payment in the county clerk's office. And once you make that payment, you'll be able to come back here and give the receipt to our court coordinator. Joshua Shane Quinton Alameda. That's just a dismissal.
Yes.
Mr. Almea is a very suspicious nature.
I'm really more concerned about.
Okay, this is cause number 24 CCCR 0424, case is style of state of Texas versus Joshua Shane Quinton Almeda. Mr. Almeda, is that your full name? How are you doing, Mr. Almeda?
Doing good about yourself.
I'm doing fine, thanks for asking, Mr. Almeda. You're represented in your case by your attorney, Attorney Joel Vasquez. Attorney Vasquez, how are you doing?
Real good, Your Honor. How are you?
I'm doing fine, thanks for asking. And Miss Simmons, I have before me a motion to dismiss this case. Is that correct?
Yes, Your Honor.
Mr. Almeda, the state has filed a motion to dismiss this case. I'm signing the motion to dismiss. You'll be able to get a copy of this motion in a few seconds from the court coordinator. Once you get a copy of the motion in order to dismiss, you're free to go, and you have a blessed day.
Thank you, Judge.
Okay, and Mr., let's see, you have another case?
Yes, Your Honor, a couple of pleas.
Oh, please.
Mr. Harris.
I think Mr. Paget's client has not joined the defendant Rubin. If he can announce on that real quick.
Okay. So that's gonna be a plea. Okay, Mr. Paget.
Yes, Your Honor. She was Had attempted. Zoom
Is
and-
Nadia Joe Rubin?
It is.
How you doing, Miss Rubin?
How you doing?
I'm doing fine. Now, Miss Rubin, you're represented in your case by your attorney, Attorney James Paget. And Attorney Paget, what's your announcement in Miss Rubin's case?
Your Honor, we have not received or reviewed all the discovery at this time. I've requested it and I've received most of it. You would give us just a non-trial setting.
Give us a reset date.
We're moving towards it. I now have an offer from Ms. Simmons.
What's the date? Okay, this case will be reset to June 9th, 2025. Ms. Rubin, your attorney and your bondsman will get notice of your reset. Stay in contact with your attorney and your bondsman. You're free to go. And you have a blessed day. Your case is reset to June 9th, 2025. And Mr. Paget, is this your last case?
Yes, Your Honor.
Okay, you're free to go as well, and you have a blessed day.
I'll call you, Ms. Rubin. You're free to go.
Nicholas Weaver.
Thank you. That's right.
Okay. This is cause number M331574. Case is style of state of Texas versus Nicholas Wayne Weaver. Mr. Weaver, is that your full name?
Yes, sir.
How you doing, Mr. Weaver?
I'm doing great. How you doing?
I'm doing fine, thanks for asking. And Mr. Weaver, you're represented by your attorney, Shillander, Mel Shillander. Mr. Shillander, how are you doing?
Okay, so no fellow there.
Okay. Now, Mr. Shillander, what's your announcement in Mr. Weaver's case?
This is, should have played, hopefully have played.
Oh, the plea is not ready yet? Okay, okay, we'll call you back up when she's working on the plea paper. Okay. Well, you need to get those, cause numbers 24 CCCR 2478 and cause number 23 CCCR 0951. Both cases are style of state of Texas versus Eric Rodriguez Mata Senior. Oh, excuse me, here's one case, which is, there's two cases.
I have
Yeah.
two cases.
Yeah. Now, Mr. Mata, how are you doing? I'm doing fine. Thanks for asking, Mr. Mata. You represented in your cases by your attorney, Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir.
And Mr. Boudreaux, what is your announcement in Mr. Mata's cases?
Your Honor, in talking to the DA, well, I think this case was transferred from county court number 3 to this court. And
Yeah.
they would like to have a little bit more time to talk to the witnesses.
Okay.
To see what we might be able to do.
Was that correct, Seth?
That's correct, Your Honor. Hasn't
Okay.
been assigned a prosecutor in our court, so we haven't reached out, but I'll get one.
Okay. Give us a reset on Mr. Mata's cases. Okay, Mr. Mata, your cases will be reset to June 9th, 2025. You will get a reset from our court coordinator. Once you get a reset from the coordinator, you're free to go. And you have a blessed day. And Mr. Boudreaux, are these your only two cases today? Let's see.
I think that's the only.
Yeah, that's it. Mr. Boudreaux, you're free to go.
Okay.
And you have a blessed day.
Thank you, Judge.
You're welcome. Yes,
You could give me a day.
Mr. Kelly. Mason. Kelly. Pat. Rojas. Shaniqua Olifant?
Yeah, the paperwork ready to.
Oh, no, that's, no, I don't have that. Ready. Okay. Peter Dahl. We have, Brianna Phobos.
Yeah.
Okay.
We, on the other, the remaining DWI, we don't have it for trial setting.
It is set for trial
I mean,
right now.
today.
Yeah.
We're not ready.
State. You have any objections to this case being reset? Okay.
Very good.
State motion for continue, I mean, the defense motion for conditions. Objections. Granted. Okay. Give us a reset date for trial. Okay, this case will be reset for trial June 16th, 2025. Ms. Phobos, you need to be present in court with your attorney for trial on that date. And Mr. Doyle, you're gonna get your reset. You're in court, and you will get your reset as well. Once you get your reset, you're free to go, and you have a blessed day.
Thanks, sir.
I was looking for somebody that. Mr. Grove,
Yes, sir.
Pamela Buie,
That's a plea, Your Honor.
that's a plea too? Okay, well, just hold up. Well, okay, just hold up.
Mr. Kelly, just have an announcement on the trial docket.
She's on Walker.
Okay. You have an announcement on the trial docket,
It's being resolved.
Kelly.
Yeah.
Okay, yes, you said it's on the trial docket?
Ashley Rolls Martinez is present.
On the trial docket? I don't see Mr. Kelly's name on the trial docket.
Langston was originally on it, Your Honor.
What's the person's name?
Ashley Rolls Martinez.
Oh, Ashley Rawls. Okay, yeah, you still have Mr. Adams on the case.
I got it.
Okay, yeah, but they should have changed it in the system. Ashley Rawls.
Present.
Okay. Almea?
Okay. Ms. Rawls, your full name is Ashley Rawls? How are you doing, Ms. Rawls?
Sir, how about you?
I'm doing fine, thanks for asking. Ms. Rawls, you representing this case by your attorney Tom Kelly.
Yes.
Attorney Kelly, how are you doing?
Doing well, Judge. Thank you very much.
And Mr. Kelly, what's your announcement?
We've got a resolution, Your Honor. I think maybe we just need maybe at most a couple weeks to.
2 weeks should be fine.
2 weeks? Give us a 2 weeks reset. This case is on the trial docket. On page 1, it has Ashley Rawls. What's that date?
It's because it can't, no, it doesn't have a criminal.
You gotta press the button. There's a button on there, just you raise like you're writing.
Okay, so what I'm gonna do is this one could be old things. So I'll come bring for just y'all. I'll come bring y'all old things.
What's that gonna be?
No, it's gonna be on a, announcement doc. What is, what docket you want it on?
Just remain on the trial. It's gonna be.
Trial docket. Put it on the trial docket. Yeah,
Okay, that'd be May 19th.
okay, this case is reset May 19th. 2025. Okay, Ms. Rawls, you're gonna get your reset from our coordinator. Once you get your reset, you'll be free to go. And you have a blessed day. Please stand in front of the court coordinator. Okay, John O'Shawn? O'Coin? Mr. O'Coin, your full name is John Eric O'Coin? O'Quinn? O'Quinn.
Yeah, it's close enough.
Okay, how you doing, Mr. O'Quinn?
Good, sir. You.
I'm doing fine, thanks for asking. Ms. O'Quinn, you're represented in your case by your attorney, Attorney Tom Kelly. And Mr. Kelly, what's your announcement in Mr. O'Quinn's case?
Your Honor, could we stay on this docket, please, so that I can get the videos from the DA's office? I think they've been made available to us. I just haven't seen them.
Okay. Let me see some. Yeah.
Well. Thank you.
Okay, now, Mr. O'Quinn.
Yes, sir.
On January 7th, 2025, the court gave you some bond conditions. You remember that? Do you remember the bond conditions that the court gave you?
Yes, sir.
One of the condition number 6 states that you must attend NA meetings 3 times a week and provide proof to the court. Do you have your verification form that the court gave you?
No, sir.
What?
I didn't get it.
You didn't get one?
No, sir. I didn't get it. So I didn't get.
Okay, you probably could check the tape, but I give out,
Sorry.
every time I get these bonds, I do the same thing. It's repetition.
Yeah.
I give you
I didn't get
a
paper,
verification form and now if he,
I think what Mr. Quinn's saying, Judge, is he didn't get a verification form, not that the court didn't give him conditions.
Oh, no, what I'm telling him is that every time I give these bond conditions, I turn to my left and reach in the file and give a verification form and one of these sheets that says where you can go for AANA meetings.
Yes, sir.
Okay.
I did get one and I did go.
Okay,
And I brought it back and you did make a copy of it,
okay.
but I didn't get one.
You didn't get
I didn't-
another
I-
one is
I
what
didn't
you're
get a-
saying.
I didn't get another one to
Okay,
on the research.
okay, okay. Let me do this here.
I think it's just a.
Oh, correspondence is probably this. Yeah. So you need another form. Yeah, we have the other form, a copy of the other form in here.
Yes, sir.
Actually, it said that, yeah. We're gonna need to make a copy We need to make some copies of this here. We need to give a copy to Mr. Oakland. There you go. Okay, we're gonna make a copy. And you need to bring that form back every time that you come to court so we can verify that you've been attending the AAM meetings. And I noticed that on this last form that you turned in, you still had a few spaces left. About 4 spaces, but she's gonna give you another one with about 20 spaces on it. Okay, so your case is going to be reset. And she's gonna give you that reset date. Once you get the reset date and the verification form, you'll be free to go. Stay in contact with your attorney. Okay, you can stand in front of the court coordinator. Sean Nicholas Causy.
Present.
Mr. Causy. Your full name is, here you go, you want to get this, your two to him. Okay. Mr. Causy, your full name is Sean Nicholas Causy.
Yes, sir.
How are you doing, Mr. Causy?
Okay, but
I'm doing fine, thanks for asking. Ms. Causy, you're represented in your case by your attorney Tom Kelly. Mr. Kelly, what's your announcement?
Judge, can I have one more setting on this announcement docket, please?
Okay, now we reset Oak Quinn's for announcement too.
Okay.
Give us a reset date on both Oak Quinn and Causy. June 9th. Okay, Mr. Causy, your case will be reset to June 9th, 2025 at 9 a.m. You will be able to get a copy of your reset from our coordinator. Once you get a copy of your reset, you're free to go and you have a blessed day.
Yes, sir.
And Mr. Kelly, you have any more cases?
I do, Judge. I'm handling a case for my friend Ben Jeffries. It's going to be a plea.
Mr. Jeffries?
Yes, Judge.
Okay, we'll come back to it.
Thank you, Judge.
Okay. So that's gonna be Kelly handling Jeffrey's case. Yeah. Briante Holland?
That door is locked. That door is locked.
Briante Holland? That person is not here. Okay, this is cause number 24 CCCR 2604. Case of style of state of Texas versus Briante Nicole Holland. Ms. Holland was scheduled to be in court at 9 a.m. at or about 9 a.m. on today's date of April 28 of 2025. The court's bailiff called the name of Briante Holland at the courthouse door. Briante Holland did not answer. Briante Holland has not appeared in court since the court has been in session. The time now is 10:48 a.m. on today's date. Ms. Bailiff, would you please call the name of Briante Holland at the courthouse door? Briante Holland's name was just called again at the courthouse door. Briante Holland did not answer. A reasonable time has passed to give Ms. Holland an opportunity to appear in court. And she has not appeared in court. State, do you have a motion?
Statements for bond forfeiture.
That motion will be granted. Briante Holland's bond will be forfeited and a warrant shall be issued for her arrest in cause number 24 CCCR 2604. And Ms. Carlton, you are excused.
Thank you, Your Honor.
Okay.
Thank you.
Yes.
Yeah.
Xavier Clayton,
We call it.
only thing about this here, this goes off by itself. I have to keep cutting it back on. It just, once I'm not using it, just automatically shut down. Okay, this is cause number, who's about, prosecutor? This is Mr. Hubel?
Yeah.
This is cause number 24 CCCR 1472 case of Solid State of Texas versus Xavier DWI Clayton. Mr. Clayton, is that your full name? How you doing, Mr. Clayton? That is great. You doing good? That's good. Now, Mr. Clayton, you're represented by your attorney, Attorney Langston Adams. Attorney Adams, how are you doing?
Well,
And Mr. Adams, what's your announcement in Mr. Clayton's case?
I'm hired on this felony case. I talked to the felony prosecutor. If we're able to resolve felony, that's gonna resolve the misdemeanor. She actually, Mofino is the felony prosecutor on it.
So, what are you saying? You're not, it's on the trial docket, you're not ready?
Because they reset the felony case so he could watch the video. And he did come to my office and watch the video on his felony case, so we need to get that. Oh, that's not my fault. But
Turn it on.
Okay, now,
so that's why I'm asking for it to be reset.
you have any objections to this, defense continues?
No objection, Your Honor.
Okay. When is the felony case set?
I have no idea. I know they reset it though. She reset it so he could watch the video. He has come watch the video. I'm talking about the felony video.
I'm set. Okay, this is reset to May. It's May 19th, that's the felony? Okay, this case will be reset on the same day as felony, May 19th, 2025. On that day, Mr. Clayton, what you will do, you'll come check in with the bailiff and then go to the felony court. And once you finish there, you'll come back here with your attorney. Now you're gonna get your reset. Once you get your reset, you're free to go and you have a blessed day. You can stand in front of the court coordinator. Shantae Naomi Martin. Yeah, that's the same. Yeah, keep it on the same docket, the felony.
Right.
Now, is this the one lady, was she's pro se? Yeah,
Right.
she's pro se and you just a standby attorney.
Oh,
Yeah, that's what your notice said. You're the standby attorney on this case.
oh,
So-
because this is my first appearance with her. Okay,
Oh,
well,
wait, I mean, she's her attorney.
so you,
Okay, so you're the standby attorney, I think we explained it to her that you are trying the case or handling the case. If you need any advice, legal advice, what you need to do, he is your standby attorney. He can give that to you. Do you understand that?
Yes, sir.
Okay, so this case is on the trial docket. What is your announcement? Are you ready for trial?
No, sir.
Okay, State, do you have any objections to this case being continued?
No objections, but I would ask if there's anything that I can help the defendant with in regards to discovery or why she's not ready.
well, I sent a request for this.
Yeah, but she's her attorney.
I can help you with getting the discovery from him directly.
Well,
Yeah, it would have to go directly to her and he would have to, I guess, give her what?
I mean, we could, anytime that she needs to review discovery, we could be at our office, Your Honor.
Okay,
And just she'd be entitled to copies of, she's not gonna sit in his office.
not in the code. Now, according to the code, this is what's 39.15 of the Texas Code of Criminal Procedure. He's not she's not entitled to copy. She's entitled to access. I think it's 39.15 or 14. Yeah, so we'll reset this case, give you an opportunity to get with the district attorney's office so you can have access to the discovery. Okay? No, she's gonna give you a reset. And then you can talk to the prosecutor to set up a time. And
Right.
okay, so just have a seat.
So don't leave till you talk to him, so you before time to come to his office.
Okay,
So y'all can personally meet in his office. Don't leave till you talk to him.
okay. And let's see.
And I have one more, and that's, oh, come on.
What else?
One more, Judge.
Oh, Sloan,
That should be a bench trial, but
Anida,
I'm ready to go today if it's not.
Your Honor, state will be submitting a dismissal in the case.
okay. Okay, so Ms. Sloan, the state will be submitting a dismissal in this case. If you want to wait around for your dismissal, we'll be able to get it to you in a few minutes. He just has to sign it. Okay, so just have a seat.
Have questions?
Oh, yeah, yes, hold on a minute. You say submit, Caleb, okay. Which one, green? Oh, I didn't sign this? I thought I signed it. I guess I just signed that dismissal.
Okay.
Do you have his dismissal? On green?
I have. And I need to make a change on Schillings. Olifant, you can send it back and then I'll send it back to you.
Okay,
And I will be next.
okay, hold on a minute. Let me send this back. to you. And you're gonna send it back?
Yeah, I'll send it right back.
Okay. Linda Simon. Linda Simon.
I thought that one for a moment.
Okay, this is cause number 25 CCCR 0106. Case is style of the state of Texas versus Linda Simon. Ms. Simon, is that your full name?
Yes.
How are you doing, Ms. Simon? That's good. Now, Ms. Simon, you're representing your case by your attorney Charles Rojas. Attorney Rojas, how are you doing?
Doing well, Judge.
And Mr. Rojas, what is your announcement in Mr. Simon's case?
Judge, this is our first appearance. I'd like to resetting to have a chance to go over the discovery. With Ms. Simon.
Okay. Okay, give us a reset date on Simon. It's on the announcement docket. It'll be June 9th. Okay, this case will be reset to June 9th, 2025. Okay, Ms. Simon, you're gonna get your reset from our coordinator. Once you get your reset, you'll be free to go and you have a blessed day. Thank you. And Mr. Rojas, this is on the case. You free to go? Okay. Yes. Sure. Hold on a minute. Sydney Monet Edwards?
Yes, sir, this is what I'm, may I approach the bench on this matter?
Yes.
I got a call, I don't know, it's 4 o'clock in the morning, 5 o'clock in the morning, that concerned her, that she was in an emergency, room. I couldn't figure out, well, I've been up late, with El Paso or San Antonio. Okay, so what I'm gonna ask for is that she's not here. I just know she's somewhere in the emergency room in West Texas. So what I'm asking is I get a day or two to get some proof that she's was there and could not appear here. And
State.
No, no objections from the state.
Because we do have a plea worked out that we agreed to. She said, Mr. Hugo sent me a plea bargain and it's agreeable with her. I just
So-
don't know which emergency room she's in itself.
So, if we do not get that,
And if she, I mean, if she can't prove that she's in the hospital, then she was supposed to be here in court. And
Be a original.
yeah, but I mean, what I have to do, I have to call it now. We'll put a hold on actually filing.
Okay.
Right.
Yes, sir.
Okay, so this is cause number 24 CCCR 1426.
Yes, sir.
Case is filed in the state of Texas versus Sidney Monet Edwards.
Yes, sir.
Sidney Monet Edwards scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Sidney Edwards at the courthouse door. Sidney Edwards did not answer. Sidney Edwards has not appeared in court since the court has been in session. The time now is 10:55 a.m. on today's date of April 28, 2025. Ms. Bailiff, would you please call the name of Sidney Edwards at the courthouse door? Okay, Sidney Edwards' name was just called at the courthouse door. Sidney Edwards did not answer. A reasonable time has passed to give Ms. Evans an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
statements for Bob, sure.
Okay, that motion will be granted, and per the agreement between the defense and the state, the court will hold off on actually filing the motion
Yes, sir.
pending receipt of an excuse
Verification.
about verification that she's in the hospital. And we give him 48 hours to do that. You give him 2 days, you said?
Yes, Your Honor.
But 2 days might be a little short. Can you give me 3? Because it's
3 days?
Yeah,
I
because,
do.
yeah.
Okay, so it's gonna be, it'll be reset for 3 days.
Yeah, because,
Well, but no, just hold off on it. 3 days, we're gonna give him 3 days to get the excuse or the verification.
yes, sir.
Okay, so you, Mr. Johns,
Yes, sir.
you're free to go,
Yes, sir.
and you have a blessed day. Mr. Grove,
Thanks, Your Honor.
okay. Okay, who do we have ready? Shaniqua Olifant? She didn't. Okay, you're welcome.
You sign this right here.
Okay, the court is in session in cause number 24 CCCR 2392. Case is styled the state of Texas versus Shaniqua Olifant. Ms. Olifant, is that your full name?
Yes, sir.
Ms. Olifant, would you please raise your right hand? Ms. Olifant, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Olifant, you may put your hand down. How are you doing, Ms. Olifant?
Good, yes, sir.
I'm doing fine, thanks for asking. Ms. Olifant, you're represented in your case by your attorney Tom Burbank. Attorney Burbank, how are you doing?
I think I have some more gray hair, but other than that, Judge, I'm doing fine.
Well, you have hair.
Well taken.
Yeah. And Mr. Burbank, do you waive a record in Ms. Olifant's case?
We do.
Ms. Olifant, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Shaniqua Olifant, on or about January 1st of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense to driving while intoxicated with an alcohol concentration level of 0.15 or more. State, are you abandoning the enhancement paragraph?
That's correct, Your Honor.
Now, the state is abandoning the enhancement paragraph, and what that means, Ms. Olifant, instead of being charged with a Class A misdemeanor DWI, you will be charged with a lesser included Class B misdemeanor offense DWI. Do you understand that? Now, Ms. Olifant, to the Class B misdemeanor offense of driving while intoxicated while you were operating the motor vehicle on January 1st of 2024 in Jefferson County, Texas, while you were intoxicated. How do you plead? Guilty, not guilty, no contest? Now, you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Oliphant, I'm showing you a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this same document, there's a set of initials, 2 sets. One set is your attorney's initials. Second set, SO, your initials. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line. Oh, no, she didn't sign here. She needs to sign on the line that's titled defendant. Okay, Ms. Oliphant, I have before me on page 3, there's a signature above the line that is titled Defendant States Exhibit Number 1. You recognize this document? I mean, this signature, is this yours?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to appeal, which means you're giving up your right to appeal. You understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. And do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Ms. Oliphant, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Ms. Oliphant, are you a citizen of the United States?
Jennifer states 1.
Objection, stage 1.
No objection, states exhibit number 1 will be admitted. And Mr. Burbank, you've advised and counseled Ms. Oliphant, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Oliphant, your attorney, Mr. Burbank, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation? Ms. Oliphant, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement? State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is 2 years deferred probation with a $500 fine, 60 hours community service, the installation and maintaining of an airlock device, and DWI standard conditions of probation.
What is a court cost? Mr. Burbank, were you appointed in this case?
I was.
You said it was $392 for the court cost? I'll share with the signs. Okay, Ms. Oliphant, the state is offering that you serve 2 years deferred adjudicated probation. During the 2 year probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll also be required to pay a DWI conviction fine or fee of $100. You'll be required to pay probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll be required to reimburse Jefferson County Court appointed attorney's fees of $350. You'll also be required to pay the Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on this probation, is $137 a month. Will you be able to pay the $137 each month?
No, Your Honor. I'm court appointed and she's introduced.
Do we have her affidavit of indigence? This is she's on a jury trial docket. Shaniqua Oliphant. When we get into the one, so. Let's see. Ms. Oliphant, I have before me a document that is titled Jefferson County Affidavit of Injuries. Hand this document to your attorney. He will hand it to you. Ms. Oliphant, do you recognize that document?
Yes, sir.
And is that your signature on the line that's titled defendant signature? Now, Ms. Oliphant, before you, now, is everything in that document still true and correct today? It is?
And I still plan on my other probation.
Okay. Okay. Do this here. So you. Let's see, 71. What's the 60? Okay, so you have probation fee in another case?
Yes, sir.
Is it like a felony case?
Oh, no, sir. But I only owe $1,000 and I'm done with it. I'll be off for that one.
But you still on it?
Yes, sir, I'm still on.
Okay. Okay. Let me see. Let's see. So this is just gonna leave. So it'll be much. Okay. Okay. Actually, that'd be 100. Okay. Now, Ms. Olifant, the court is gonna find that you're indigent. And pursuant to Article 42.15 of Texas Code of Criminal Procedure, your fine of $500 plus court costs of $392 will be converted to 71 hours of community service. The attorney's fees in this case of $350 will be waived pursuant to Article 26.05G-11. That means you won't have to pay that. And the reimbursement fee of $15, excuse me, will be waived pursuant to Article 102.018 of Texas Code of Criminal Procedure, which means you won't have to pay that. And because you're currently on probation, you will not be required to pay probation fee and a urinalysis fee in this case because you're paying it in the case that you're on probation in. Okay? So that leaves the $100 conviction fee, DWI conviction fee, and over the term of probation, you'll be required to pay that back in the amount of $4 a month. Okay? $4 a month. Will you be able to pay that? Yes. Okay? Now, when if you get off, once you get off of probation on the other case, then these probation fees will kick in. But until you do that, you will not be required to pay the probation fee. Okay? Now, let me do this. Yeah. And the probation officer, they'll make the necessary adjustments on your plea papers. Okay. Now, also, you'll be required to perform 60 hours of community service. That's in addition to the 71 hours, which comes to a total of 131 hours of community service. You have 71 hours from the fine and court cost that was converted to community service. And then you have the 60 hours of standard community service hours, which leaves you a total of 131 hours of community service. Do you understand that? You'll also be required to install an interlock device on any vehicle that you own or operate, attend and complete a DWI education class, have an alcohol assessment, and you will be required to pay Jefferson County DWI education initial evaluation fee of $125. Now, you will also be required to adhere to the other standard terms and conditions of this probation. Ms. Olifant, do you understand the state's offer?
Yes, sir.
And the adjustments that the court made in this case?
If I don't have a vehicle,
Yeah, any vehicle that you own or operate.
yeah, I don't have, I can drive.
Okay, so if you driving somebody else's vehicle,
Not all the time, just every blue moon.
every blue moon, if you're driving a vehicle, it needs to have an interlock on it. Okay, so any vehicle that you own or operate, even if you operate it one time, you can't get in and drive it if it doesn't have an interlock device on it. Okay, do you understand that? All right. Now, do you understand the state's offer and the court's adjustments?
Yes.
And do you think that is fair and just? And do you accept it? Okay, Ms. Olifant, I'll follow the plea bargain agreement with the court's adjustment. Ms. Olifant, you're gonna have a seat because they need to make the changes on the paperwork. And Mr. Burbank, is this your only case?
Mr. Ward.
Ward?
No.
Okay, James Lee Ward. Okay, we have 1, 2, 3, 4 cases. Cause numbers 23 CCCR 0598, cause number 23 CCCR 0599, cause number 23 CCCR 0605, and cause number 23 CCCR 0611. Mr. Ward, your full name is James Lee Ward. How you doing, Mr. Ward? I'm doing fine, thanks for asking. Mr. Ward, you're representing your cases by your attorney, Tom Burbank. Attorney Burbank, what's your announcements in Mr. Ward's case?
All right, that's to be reset with the felony. I was just reset this morning.
I mean, all these cases,
They're all stem from the same incident.
same criminal episode? Okay, give us a reset date. Oh, what's the reset on the felony?
Did I watch the video? No. Just let me check. I didn't watch it. You wanted to-
Do we have June 9th? Okay, Mr. Ward, your cases will be reset to June 9th, 2025. Same date as your felony cases. And Mr. Ward, you're gonna get your reset from our court coordinator. Once you get your recess, you're free to go. On that day, you need to appear here in court with the bailiff, check in, and once you check in with the bailiff, you go take care of your felonies, and once you finish your felonies, you'll come back here.
Yes, sir.
All right, now you're gonna get your recess. Once you get your recess, you're free to go, and you have a blessed day. And Mr. Burbank, these are your last cases.
What happened to one?
Who?
Yvonne, Deleon?
Who?
What's your case? It's right above.
Oh, Trevani Slaughter. He's here. That's Mr. Burbank.
And then hold on.
Okay, Mr. Slaughter.
Sir.
Your full name is Trevani Slaughter. How you doing, Mr. Slaughter? I'm doing fine, thanks for asking. Mr. Slaughter, you're representing your cases by your attorney, Attorney Tom Burbank. Mr. Burbank, what's your announcement, Mr. Slaughter's case?
This is for a reset. I need to get a hold of him. We need to make a appointment, sit down, look at all the evidence and see if we can get this gentleman out of this.
Okay, now, Ms. Segura,
Yes.
you're gonna reset Mr. Slaughter's case on the same day as
Yeah.
June 9th. These cases will be reset June 9th, 2025. Mr. Slaughter, you're gonna get your reset from our court coordinator. Once you get your recess, you're free to go, and you have a blessed day.
Now, may I be excused?
Yes, you may be excused. Juan Azakor. So this is cause number 25 CCCR 0142, case is style the state of Texas versus Juan Azakor. Mr. Azakor, is that your full name?
Yes.
Mr. Azakor, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Azakor, you may put your hand down. How are you doing, Mr. Azakor?
I'm free.
I'm doing fine, thanks for asking. Mr. Azakor, you're represented in your case by your attorney Walter Windler. Mr. Windler, how are you doing?
Fine, Judge. Thank you.
And Mr. Windler, do you waive a record in Mr. Azakor's case?
Yes, Judge.
Mr. Azakor, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Juan Azakor, on or about September 22nd of 2024, while you operated a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with alcohol concentration level of 0.15 or more. State, are you abandoning the enhancement paragraph?
Yes, Your Honor.
The state is abandoning the enhancement paragraph in this case, Mr. Azakor. And what that means, instead of being charged with a Class A misdemeanor DWI, you will be charged with a Class B misdemeanor offense DWI. Mr. Azakor, do you understand what you have been charged with?
Yes,
And to this charge, Mr. Azakor, how do you plead? Guilty, not guilty, no contest?
not.
No contest? Now you pleading no contest freely and voluntarily? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Then, Mr. Azakor, I also have before me on my tabs of the document that is titled misdemeanor plea admonishments. You recognize this document?
Yes.
On page 2 of the same document, there's a set of initials on the line next to a box that's checked. No contingent, which means no contest. You place your initials on this document.
Yes.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document that is titled discovery certification. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant? Mr. Azakor, before you signed and initialed these documents, did your attorney, Mr. Windler, go over these documents with you?
Yes.
And did you understand everything that Mr. Windler went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Azakor, are you a citizen of the United States?
No.
Okay, let me do this. Mr.
Oh, I forgot about this, Judge.
Okay.
The council for.
Yes, Mr. Azakor, I'm handing your attorney a document that is titled English Statement Number 1 for all foreign nationals except those from mandatory notification countries. Now, Mr. Azakor, what country are you from?
Mexico.
Okay. Now, he's gonna sign the top portion. The attorney is gonna go over that document with you. You can make your choice, and then we'll. It is titled English Statement Number 1 for all foreign nationals except those from mandatory notification countries. Do you recognize this document?
Yes.
And is this your signature on the line that's titled signature? Now, there's one word that circles no and is below a statement that reads, do you want us to notify your consular officers at this time? You circle no, is that correct?
Yes.
Now, also, we're gonna go back to State's Exhibit Number 1. On State's Exhibit 1, there's a set of initials below a paragraph that on State's Exhibit Number 1 that's titled citizenship. And the paragraph states that if you're not a U.S. citizen on a plea of guilty or another contingent, it may result in your deportation, exclude permission to this country, or denial of naturalization of federal law. Do you understand that?
Yes.
And you initialed this document showing that you understood what I've just stated to you. And Mr. Azakor, do you still want to go forward with your plea bargain? Okay. Now, Mr. Azakor, did we get his discovery?
Yes, Your Honor.
You have
I
his
think you
discovery?
handed it to-
You have his discovery?
Who is it?
Azakor. Okay, now, Mr. Azakor.
Yeah.
Before you sign and initial all these documents that I just showed you, did Mr. Windler go over these documents with you? And did you understand everything that you went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Okay? And state there was no objections, is that?
We'll offer the state-
You offer states one,
Yes, Your Honor.
and you have any objections?
No objection.
No objection, states exhibit number one will be admitted. Mr. Windler, you've advised and counseled Mr. Azakor. Is there any evidence that he is currently mentally incompetent to stand trial?
No evidence, Judge.
And, Mr. Windler, did you advise Mr. Azakor of the consequences of him pleading guilty of no contest by virtue of him not being a citizen of the United States pursuant to the case of Padilla versus Kentucky?
Thoroughly.
Okay, now, Mr. Azakor, your attorney, Mr. Windler, has advised and counseled you. Are you satisfied with his service, with his services? Okay, Mr. Azakor, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I'll also find that your plea and waivers were freely and voluntarily given. And I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we would ask the court for 1 year of deferred adjudication, fine of $500, repayment of court costs, 40 hours of community service, requirement of the interlock device, and then the standard terms and conditions for probation for a DWI first.
Okay. What is this court cost? What is this court cost?
What document is it on?
It's on the announcement docket, page 7.
392.
Okay, thanks. Okay, Mr. Azakar, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll also be required to pay probation fee of $60 a month, your announcement fee of $15 a month, reimbursement fee of $15. You'll also be required to pay the $100 DWI conviction fee, and you'll also be required to pay Jefferson County DWI education and initial evaluation fee on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $15. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $173 a month. Mr. Azakor, would you be able to pay the $173 each month?
Yes, sir.
You will also be required to perform 40 hours of community service, install an interlock device on any vehicle that you own or operate, attend and complete a DWI education class, have an alcohol assessment, and adhere to the standard terms of DWI probation. Mr. Azakor, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Mr. Azakor, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Azakor, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for a non-disclosure. And you may, you can ask your attorney about the non-disclosure because he's quite competent in those matters. Now, Mr. Azakor, you will stand in front of the, stand next to the bailiff and follow her directions. Once you finish following her directions, You'll be free to go. And you have a blessed day.
Thank you, Judge.
Yeah, I already did it. I just sent it to you.
Can Weaver next?
Weaver, Nicholas Wayne Weaver,
Sir.
Yeah.
Nicholas Wayne Weaver.
I'll find it. Okay, thank you. Well, look, you're gonna roll. I think this should go. No, look, I got it. Okay.
Sure, Landon. Okay. Bless you. Bless you. Okay, Mr. Weaver, your full name is Nicholas Wayne Weaver.
Yes, sir.
Mr. Weaver, would you please raise your right hand? Mr. Weaver, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir,
Mr. Weaver, you may put your hand down. How are you doing, Mr. Weaver?
I'm doing good, man.
I'm doing fine. Thanks for asking. Mr. Weaver, you're represented in your case by your attorney Mel Shalander. Mr. Shalander, how are you doing?
I'm better than I was an hour ago, Judge.
Yeah, I know what you mean. Now, Mr. Shalander, do you waive a record in Mr. Weaver's case?
We do.
Okay, Mr. Weaver, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Nicholas Wayne Weaver, on or about November 13 of 2021, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespassing. Mr. Weaver, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Pleading
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Weaver, I have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on the line next to boxes checked null or contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir. It is.
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Indeed, it is. Yes, sir.
And at the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document that is titled discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
It is.
Now, Mr. Weaver, before you signed and initialed all of these documents that I just showed you, your attorney, Mr. Shalander, go over these documents with you.
Indeed.
And did you understand everything that your attorney went over?
I do.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir. It is.
They don't say one.
Well, any objections
No
to Stacy exhibit number 1?
No.
No objections, Stacy exhibit number 1 will be admitted. Mr. Weaver, are you a citizen of the United States?
Sir, I am. Yes, sir.
Okay. And Mr. Shalander, you've advised and counseled Mr. Weaver. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Weaver, your attorney, Mr. Shalander, has advised and counseled you. Are you satisfied with his services?
So far, yes, sir.
Okay, Mr. Weaver, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 7 days in the Jefferson County Jail, credit for 7 days, and tax and retire all court costs.
Okay, Mr. Weaver, the state is offering that you serve 7 days in the Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail because you've already served 7 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Weaver, do you understand the state's offer?
I do, Your Honor.
And do you think that the state's offer in your case is fair and just?
I do, Your Honor.
And do you accept the state's offer?
I accept the state's offer.
Mr. Weaver, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Weaver, you'll stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go and you have a blessed day.
So I have to go to jail?
No, you won't have to go to jail. You've already served your time in jail.
I don't know if you'd have to check in.
No. Jose, Tahina,
Where?
that's, Joe Vasquez. Is that Jose Tahina Saavedra? Okay, how you doing, Mr. Saavedra? Okay, Mr. Saavedra, would you please raise your right hand? Mr. Saavedra, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Saavedra, you may put your hand down. Mr. Saavedra, you're representing your case by your attorney, Joe Vasquez. Attorney Vasquez, do you waive a record in Mr. Saavedra's case?
Yes, sure.
And Mr. Saavedra, I have, let's see, this is. Okay, Mr. Saavedra. I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jose Terrena Saavedra, on or about September 20th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. State, are you abandoning the enhancement paragraph in
We
this
are, Your
case? Oh, thing is not working. There we go. Now, Mr. Saavedra, the state is abandoning the enhancement paragraph, and what that means is instead of being charged with a Class A misdemeanor DWI, you'll be charged with a Class B misdemeanor offense DWI. Do you understand that? Okay, now, Mr. Saavedra, to the Class B misdemeanor offense of driving while intoxicated, which allegedly occurred on or about September 20 to 2024, while you operated a motor vehicle in a public place in Jefferson County, Texas, how do you plead? Guilty, not guilty, or no contest? Now, you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? You have to speak up. That's what no contest means, that you're not fighting and contesting charge. Now, Mr. Saavedra, are you pleading no contest freely and voluntarily?
Yeah.
All right. Now, Mr. Saavedra, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yeah.
On page 2 of the same document, there's a set of initials on the line next to a box that's checked no contendere. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yeah.
And on the next document that's titled Trial Court Certification of the Defendant's Right of Appeal, do you recognize this document?
Yeah.
And is this your signature on the line that's titled Defendant? Now, Mr. Saavedra, at the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yeah.
I also have a document that is titled Discovery Certification. Do you recognize this document?
Yeah.
And is this your signature on the line that's titled Defendant? Now, Mr. Saavedra, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you? And did you understand everything that your attorney went over?
Yeah.
And is everything in these documents true and correct to the best of your knowledge?
Yeah.
Now, Mr. Saavedra, are you a citizen of the United States?
No.
Okay, did you sign the form? Mm. What country are you from? Mexico? Here you go.
Thank you, Judge.
I have before me a document that is titled English Statement Number 1 for all foreign nationals except those from mandatory notification countries. Do you recognize this document? And is this your signature on the line that's titled signature here? And there's one word that's circled. The word that's circled is no, and it is below a statement that reads, do you want us to notify your consular officers at this time? And you said no. Is that correct? Is that correct?
That's correct.
Okay. Now, before you signed this document, did your attorney go over this document with you?
Yeah.
Did you understand everything that he went over?
Yeah.
Is everything in this document true and correct to the best of your knowledge? Now, there's another statement on State's Exhibit Number 1. There's a set of initials below this paragraph, and the paragraph is titled Citizenship, and it states that if you're not a U.S. citizen on a plea of guilty or contingent, it may result in your deportation, exclusion from admission to this country, or denial of naturalization under federal law. Did your attorney go over this statement with you?
Yeah.
And did you understand this statement?
Yes.
And do you still want to go forward with your plea bargain?
Yeah.
Okay, now, okay.
Statement offer states why this time, Your Honor.
No objection.
No objections. State's Exhibit Number 1 will be admitted. And just for the record, all of the documents that we went over, your attorney went over these documents with you. Is that correct?
Yes.
All right. Now, Mr. Vasquez, you've advised in counsel, Mr. Saavedra. Is there any evidence that he's currently mentally incompetent to stand trial?
No.
Now, pursuant to the case of Bediz versus Kentucky, did you advise Mr. Saavedra of the consequences of him pleading guilty in no contest since he's not a citizen of the United States?
Yeah, sure.
Okay. Now, Mr. Saavedra, your attorney, Mr. Vasquez, has advised in counsel. Are you satisfied with his representation?
Yeah.
Okay, Mr. Saavedra, I will accept your plea of no contest. I will find that you're mentally incompetent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. We'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 15 months deferred probation, $500 fine, 80 hours community service, and Olifant DWI first state or condition of probation.
Mr. Vasquez, were you appointed in this case?
Yes, Your Honor.
What's the court cost? The court cost is $350?
Yes.
Okay, Mr. Saavedra, the state is offering that you serve 15 months deferred adjudicated probation. During the 15-month probationary period, you'll be required to pay a fine of $500 plus court costs of $350. You'll also be required to pay a DWI conviction fee, fine of $100. You will also be required to pay a probation fee of $6,000 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you'll be required to reimburse Jefferson County Court appointed attorney's fees of $350. Your total monthly installments. That is the total amount that you'll be required to pay each month. In this case, is $174 a month. Will you be able to pay the $174 each month? Yes. You'll also be required to pay Jefferson County DWI Education Initiative Evaluation fee of $125 on the day of the police shift for the evaluation if needed. You'll be required to pay an additional $50. You'll also be required to perform 80 hours of community service, install an interlock device in any vehicle that you own or operate, attend a completed DWI education class, have an alcohol assessment, adhere to the other standard terms and conditions of this probation. Mr. Saavedra, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer? Do you accept the state's offer?
Yes.
Okay, Mr. Saavedra, I'll follow the people are in agreement that you have entered into with the state. Mr. Saavedra, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Mr. Saavedra, you will stand next to the bailiff, follow her direction. Once you finish following her directions, you're free to go. And you have a blessed day. And Mr. Cartwright?
Yes, sir.
You had a case? I'm doing fine. Let's see if I can. Dallas Cleavell. Mr. Cartwright, you stand on this side and he'll stand in the middle.
How you doing?
Okay, I'm doing fine. Mr. Cleavell, your full name is Dallas Cleavell Jr.
Yes, sir.
How you doing, Mr. Cleavell?
Pretty good. And yourself?
I'm doing fine, thanks, Max. Ms. Cleavell, you represented in your case by your attorney, Rubin Cartwright. And Mr. Cartwright, how are you doing?
I'm doing well.
That's good, Mr. Cartwright. What is your announcement in Mr. Cleavell's case?
All I can see.
Okay, you're gonna keep it on the announcement docket? Okay, give us a reset.
June 2nd.
Okay, this case will be reset to June 2nd, 2025, at 9 a.m. Mr. Cleavell, your attorney, you and your attorney get a copy of the reset from our court coordinator. Once you get a copy of the reset, you're free to go. And you have a blessed day. And Mr. Rubin, is this your only case? Okay, you're free to go as well, and you have a blessed day.
Thank you.
All right.
Same to you.
All right, thank you. Mr. Grove,
Yes, sir.
we got his ready. Which one is that one? Pamela Buie? Pamela Buie.
She's outside, Judge, she's here, she's on a roller or wheelchair type thing,
Okay,
she is here.
okay. Buie.
No, I said we're gonna plea.
Okay, y'all ready?
Yes, sir.
Okay, this is clause number 24 CCCR 0828 case of Solid State of Texas versus Pamela Buie. Ms. Buie, is that your full name?
Correct.
Ms. Buie, would you please raise your right hand? Ms. Buie, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Buie, you may put your hand down. How are you doing, Ms. Buie?
Highly favored, sir.
It can't be better than that. Now, Ms. Buie, you're represented in your case by your attorney, Attorney David Grove. Attorney Grove, how are you doing?
Real good today, thank you.
That's good. Now, Mr. Grove, do you waive a record in Ms. Bowie's case?
Yes, Your Honor.
Ms. Buie, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Pamela Buie, on or about February 18th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault, family violence. Ms. Buie, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Buie, how do you plead? Guilty, not guilty, and no contest?
No contest.
Now, you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Correct.
Ms. Buie, I also have before me a document that is titled misdemeanor plea admonishments. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that says check nolo contendere, which means no contest. Did you place your initials on this
I
document?
did.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
It is.
And on the next document that's titled trial court certification of the defendant's right of appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
It is.
At the top of this document, there are 2 boxes checked.
Mhm.
The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
I do.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
I do.
And is this your signature on the line that's titled defendant?
It is.
Ms. Buie, before you sign and initial these documents, did your attorney go over these documents with you?
Yes. it-
And did you understand everything that your attorney went over?
Yes, I do.
And is everything in these documents true and correct to the best of your knowledge?
It was that.
Ms. Buie, are you a citizen of the United States?
I am.
State officers one.
Any objections?
No objection, no.
No objection, states exhibit number 1 will be admitted. Ms. Grove, you've advised in counsel, Ms. Buie, is there any evidence that she is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
And Ms. Buie, your attorney, Mr. Grove, has advised and counseled you. Are you satisfied with his representation?
I am.
Has he provided full, effective, and competent legal representation?
Yeah.
Ms. Buie, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for defendant's plea, the state's offering 90 days probated over 1 year, $500 fine, 50 hours community service, anger management, and the defendants have no contact with the complaining witness initialed JE.
The $100 fee to the crime victim.
Yes.
What's the court call? I think so. I said 277.
Move. 277.
Okay, Ms. Boyd, the state is offering that you serve 90 days in Jefferson County Jail, but you would not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $277. You'll also be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Mr. Grove, were you appointed in this case?
Yes, Your Honor.
What is that?
Long time ago, just 3 years ago.
Okay.
Nothing.
Okay. Now, Ms. Buie, you also be required to reimburse Jefferson County Court appointed attorney's fees of $250. You have to pay $100 to a family violence center in our community. Your total monthly installments, that is the total amount that you would have to pay each month, is $186 a month. Are you able to pay the $186 a month?
No, sir.
Okay, let me see her affidavit of indigence. Okay. Now, Miss Buie, I have before me a document that is titled Jefferson County Affidavit of Injuries. I'm going to hand this document to your attorney and he'll hand it to you for you to look at. Ms. Buie, do you recognize that document?
Yes, sir.
Okay, on page 2 of that same document, there's a signature in the top left-hand corner above the line that is titled Defendant's Signature. Is that your signature?
Yes, sir.
Okay, now, Ms. Buie, is everything in that document true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Ms. Buie, the court is going to find that you're indigent, and based on the finding of indigency, the attorney's fees of $250 will be waived, which means you will not have to pay it. The reimbursement fee of $15 will also be waived, which means you will not have to pay that either. The probation fee in this case will reduce to the statutory minimum of $25 a month instead of $60 a month. Now, you will, and the fine of $500 and the court cost of $277, which comes to a total of $777, will be converted to 65 hours of community service. And you will be required to pay a crime victim fee of $100. You have to reduce the amount of probation fees of $25 a month. And if you're an asked fee of $15 a month, your total monthly installments, instead of being $186 a month, will be $53 a month. Will you be able to pay the $53 each month?
I'll try, sir.
No? Okay, so you're unable to pay that one as well? Okay, so let's do this. Where is it? Okay. Here we go. Now. Wait, this. And that's gonna take out that. And that's two. Okay. 26,000. Okay, now, Miss Buie, the court is going to waive the probation fees pursuant to Article 42A.05, 42A.652, subsection B of the Texas Code of Criminal Procedure. Because the court has found that the payment of the reimbursement fee in this case will cause you to have a significant financial hardship. You will not be required to pay that. And so therefore your fees that you'll be your total monthly installments in this case will be $26 a month. Okay?
Yes, sir.
And you'll be able to pay the 26 each month.
Yes, sir.
All right. Now, Miss, okay. Now, Miss, this one's right here. Now, Miss Buie, do you understand the state's offer and the court's adjustments?
Yes.
Do you think that is fair and just?
I appreciate it. Yes, sir.
And do you accept it?
Yes, sir.
Okay, I'll follow the plea bargaining agreement with the court's adjustments in this case. Okay, just have a seat. Wait for your name to be called. Once your name is called, you'll go to the once your name is called, you'll follow the directions of the bailiff. Jamarian Stoker. Let me see, I got a sticky that's pointing next to it. 42A.652B. Yes, little B. Now, Miss, Stoker. Ms. Stoker, your full name is Jamarian? Jamarian. Okay, Jamarian. How are you doing, Ms. Stoker? I'm doing fine, thanks for asking. Ms. Stoker, would you please raise your right hand? Ms. Stoker, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Stoker, you may put your hand down. Ms. Stoker, you're represented in your case by your attorney, Attorney Alvin Samuel. Attorney Samuel, how are you doing?
I'm pretty good, Jerry.
That's good. Now, Mr. Samuel, I have before me a motion to withdraw as counsel in this case.
Yes.
That was filed, Ms. Stoker. Do you recognize this motion? You get a copy of this motion to withdraw? As your attorney of record?
Yes, sir.
Okay. Now, do you have any objections to Mr. Samuel getting off of your case?
No, sir.
Okay,
Yeah,
we have an order, huh?
may I make a statement?
Yeah,
Your Honor, as a result of this case, the lost her employment. We almost to the end of this, but she wasn't able to
I understand.
adhere to the contract. So if the court, this is one that I would take to finish if the court would appoint.
Yeah, but you're not on our court appointed list.
I understand.
Yeah, okay. So at this time, Ms. Stoker, your attorney, Mr. Samuel, is being granted the motion to withdraw. He is no longer representing you in this case. Now, Ms. Stoker, is there an affidavit of indigence in her file? Okay, yeah, Mr. Samuel, your services, well, you're no longer attorney of record for Ms. Stoker.
Thank you, sir.
You're free to go and you have a blessed day. Here you go. Huh? Oh, I thought somebody was looking for some of her affidavits. Oh, okay. A total of is what?
115,
Yeah, just have a seat right there. We'll call you back up.
Good afternoon, Judge. This is Mr. Galmore. I don't know who's in the courtroom, so I can't see, but I have an announcement to make whenever your court's ready.
Give her an affidavit. Okay, hold on a minute. Could you give Ms. Stoker an affidavit and the judge's explanation? Okay, Stephen Renard Campbell.
Yes, sir.
How you doing, Mr. Campbell?
I'm doing fine. How about yourself?
I'm doing fine. Thanks for asking. Mr. Campbell, you represented in your case by your attorney Dustin Galmore, who is also appearing via Zoom. Mr. Galmore, how are you doing?
I'm great, Judge. How about you?
Okay, I'm doing fine. Thank you for asking. Now, Mr. Galmore, what's your announcement in Mr. Campbell's case?
Judge, we'd like to place him on the plea docket.
Okay, give us a reset it for plea. Okay, this case will be reset to June 2nd, 2025 at 9 a.m. Mr. Campbell, you need to be in court on that day. Stay in contact with your attorney and your bondsman. Your attorney and your bondsman will be given notice of your reset date. You're free to go and you have a blessed day. Mr. Galmore, your reset will be sent to you. Next case is Land Hunter C. Husen. Mr. C. Husen, your full name is Lane Hunter C. Husen.
Yes, sir.
How you doing, Mr. C. Husen?
Good, Your Honor. How are you?
I'm doing fine. Thanks for asking, Mr. C. Husen. You're representing your case by your attorney Dustin Galmore. Attorney Galmore, what's your announcement in Mr. C. Husen's case?
Same announcement, Judge. We need his plea setting.
Okay, reset it on, is that June 2nd? Your case is reset at June 2nd, 2025 at 9 a.m. You're gonna get your reset? Once you get your reset, you're free to go, and we'll see you on June 2nd, 2025.
Yes, sir.
All right, at 9 a.m. All right.
Thank you.
You're welcome. Mr. Galmore, is this your last case?
It is. Thank you, Judge.
Okay, you're free to go and you have a blessed day.
You too.
You have Mr. Kelly,
Yes, sir.
Huh?
I am.
that's on Jeffries.
Yes.
Okay, Bernice Elton Wilson Jr.
He's present. Thank you.
Mr. Wilson, your full name is Bernice Elton Wilson Jr.
Yes, sir.
How are you doing, Mr. Wilson?
I'm doing you.
I'm doing fine, thanks, thanks. Mr. Wilson, you representing your case by your attorney. Well, you represented by attorney Benjamin Jeffries. Attorney Jeffries is not here. However, standing in for Mr. Jeffries is attorney Tom Kelly. Does Mr. Kelly have your permission to stand in for Mr. Jeffries?
Yes, sir.
Okay, Mr. Kelly, how are you doing?
Still good, Judge. Thank
And
you.
what's your announcement?
This is a plea, Judge.
Let's see. See if we got it. You don't have it?
What's that, Joe?
It's a plea on a Bernice.
It's not right now, I'm going to Paris right now.
Oh,
I hate when it's like-
okay. Just have a seat. We'll call you back up. Yeah, okay. James Harris,
I didn't hear me.
Is this your honor?
James Harris. Mr. Harris, your full name is James Willie Harris. Mr. Harris, would you please raise your right hand? Mr. Harris, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Mr. Harris, you may put your hand down. How are you doing again, Mr. Harris? That's good. Mr. Harris, you're represented in your case by your attorney, Attorney Joel Vasquez. And Mr. Vasquez, do you waive a record in Mr. Harris's case?
Yes, sir.
Mr. Harris, I have before me a document that was filed by the Jefferson County District Attorney's Office. This document is titled Information. In this information, Mr. Harris, it alleges that you, James Willie Harris, on or about March 9th of 2022, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of communication harassment. Mr. Harris, do you understand what you've been charged with?
Yes, sir.
To this charge, Mr. Harris, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest these charges? And this offense occurred on March 9th, 2022. Now, Mr. Harris, I also have a document before me that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this same document, there's a set of initials on a line next to a box that's checked nola contingere, which means no contest. You place your initials on this document.
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, there's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box is checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line? It's titled Defendant. And Mr. Harris, before you sign and initial all of these documents, did your attorney go over these documents with you? And did you understand everything that your attorney went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Harris, are you a citizen of the United States?
Yes, sir.
State offer states one.
No objection.
No objection. States exhibit number 1 will be admitted. Mr. Vasquez, you've advised and counseled Mr. Harris. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Harris, the attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Mr. Harris, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for defendant's plea, the state's offering 90 days prorated over 1 year, $500 fine, 60 hours community service, and the defendant is to have no contact with the complaining witness, Louis Harris.
Mr. Vasquez, were you appointed in this case?
Yes, Your Honor.
No. It is an outlier. I'll be making an announcement.
Okay, Mr. Harris, the state is offering that you serve 90 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $377. You'll also be required to pay a probation fee of $60 a month. You're now to pay $15 a month. Reimbursement for $15, and you'll be required to reimburse Jefferson County court-appointed attorney's fees of $350. Your total amount of installments, that is the total amount that you will be required to pay each month, is $191 a month. Will you be able to pay the $191 each month? You will also be required to perform 60 hours of community service. You cannot have any contact with the complaining witness, in this case, Louis Harris, and you will be required to adhere to the other standard terms and conditions of this probation. Mr. Harris, do you understand the state's offer? Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes.
Mr. Harris, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Harris, this will conclude your case. Please have a seat, wait for your name to be called. Once your name is called, you'll follow the directions of the bailiffs. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day.
Your Honor, Mr. Harris has an ankle monitor. It's a condition of the
Okay.
bond, and he's eager to get rid of it.
Okay, I need that. Could you, somebody reach me a copy of those, the release, the ankle monitor?
To release what? I mean,
It's a GPS. Okay, Mr. Harris, the court has just signed this motion to remove the GPS monitoring system device. You could get a copy of it. If you need a certified copy, you'd have to go downstairs in the clerk's office.
You want to take that to
You should be able to take that.
Yeah, that's
If they need it certified, they'll get another one.
okay.
Okay, Mr. Rivas, your full name is Juan Manuel Rivas?
Yes.
How you doing, Mr. Rivas?
Good, how you?
I'm doing fine. Now, see here, you have a felony case?
Yes, sir, I did real quick.
Okay, and this case was reset with the felony case. You had that felony case set today?
They said that I was, Belmont's calling me on Friday and said that I had court here with you
Right.
today. Cause you know how they call Friday.
Okay. Hold on, let me see Rivas. This is Mr. Rivas. He's on the announcement docket page, the last one on page 7.
Felony is in drug court. Okay. And it's set for announcement plea for May 19th, Your Honor.
And he also, his case, your case was reset for you to hire an attorney. Have you hired an attorney?
I was looking through that. It seems kind of expensive because I already have a attorney for the other one. I was trying to see if I could sign an affidavit to get up.
Okay. Just have a seat. She's gonna get you the paperwork. You need an affidavit of indigence. Miss Mosley, he needs an affidavit of indigence and the judge's explanation. Just have a seat, she'll bring it to you.
Curtis Wilson.
Well, you probably need to sit at the table because you're gonna have to, she's gonna give you a pen too. Okay, and on a clipboard. Heriberto Rubacala, Caba, Rubacala, Caba. Rubacaba. Mr. Rubacaba, your first name is Heriberto. How are you doing? Now, your case was reset for you to hire an attorney. Have you hired your attorney?
Brady came in and that's why, but
What did he say?
I really came out, I was offshore, really came in, but.
Oh, you just came back inland? So you need more time? Okay, this is Mr. Rubacaba. He's on page 8. We're gonna give him more time to hire his attorney. This case will be reset to June 2nd, 2025. You're gonna get your reset from our court coordinator. Now, if you hire an attorney before that, your attorney probably gonna get this court date reset.
Yeah, I was talking to right here.
Okay,
Your Honor, if there's no pleas ready, we do have a pro se, Mr. White, that's, we can announce him today, that's not pleading.
you said that's a plea.
It's not gonna be, if the. pleas
Yeah, he
aren't
was
written-
next. Aaron Scott White. Mr. White? Come forward. Mr. White, your full name is Aaron Scott White?
Yes.
Okay. Now, Mr. White, you were representing yourself, that's correct? And what is your announcement in this case?
We have more information on the case itself, and I did go over some of the discovery, but just the reports and
So
then.
you need more time
Yes, sir.
for the discovery? Okay, give us a reset. This is Aaron Scott White, right below Mr. Rubacaba. Okay, this case will be reset to June 2nd. Give you an opportunity to get with the state to go over your discovery. Once you get your reset, you're free to go. And you have a blessed day. Please have a seat in that 4th chair on the wall.
Oh, okay.
Please. What, Daisy Sam?
Yes, sir.
I don't believe that's a plea, Your Honor.
Hmm?
I don't think.
Miss Sam, your full name is Daisy M. Sam.
Yes, sir.
How are you doing, Miss Sam?
I'm doing okay. How are you?
I'm doing fine, thanks for asking. Miss Sam, you're representing your case by your attorney, David Grove. Mr. Grove, how are you doing?
Good, Judge, thank you.
Okay, Mr. Grove, what's your announcement in Miss Sam's case? This case is on the trial docket.
I believe Ms. Sam still wants to go to trial. She does not wish to accept the
Okay,
plea bargain offer that has been offered by.
okay, are you ready
for
for trial?
Ready for trial? I believe we're ready. Judge.
Okay, State, are you ready?
It's my understanding, I just got word from Mr. Hubel that he's announcing ready on the theft, Your Honor, but the other two are being disposed of separately, is that correct?
The other two being dismissed, you said?
No.
We
So
got-
they're announcing ready on the theft?
Yes, Your Honor.
Well, you gotta, she was arrested for theft and she also had 2 other cases at the time. when she
Yeah, it
was
says
arrested.
one of them is a
And then
gun
there's
case.
2 other ones subsequently. And on the subsequent one, she had as a new DWI that hadn't been filed, hadn't been received by the DA's office.
Well,
So I'm just saying, so there's 6 cases.
Your Honor, Mr. Hubel's announcing ready on the theft, and the other two, as far as I'm concerned, he.
right.
It's only the fifth case from 2022. And the position of the days is
And unlawfully carrying a weapon.
Those two, from my understanding, are not trial, Your Honor.
Right.
And it was a DWI who's supposed to be involved with that.
with the unlawful carrying a weapon.
Yes.
So that's separate. This is not all on the same day. So the state is ready on the theft case.
I think that's what Mr. Hubel said, yes.
Right. And so you're ready?
Yes, sir.
Is it correct? Okay, so we'll see y'all at 1:30. That's on the theft case.
I'm the only one down here.
Okay. They left you.
Agreed not.
They need-
I'm not.
Well, I have Terrence handwriting, so I can read Terrence.
We have, who? She's coming back at 1:30. For trial. On the theft case. Who's the next one? You have, who you working on now? Wilson? Is it ready? Okay, hold on a minute.
Ready one, so we can.
Alton Gidry? Alton Gidry, please come forward. Okay, this is cause number 23 CCCR 2522, case of Styles State of Texas versus Alton Thomas Gidry Jr. Mr. Gidry, is that your full name? Mr. Gidry, how are you doing? You doing fine? That's good. Now, Mr. Gidry, you represented in your case by your attorney, Attorney Todd LeBlanc. Attorney LeBlanc is appearing via Zoom. Attorney LeBlanc, how are you doing?
I'm good, Judge, thanks.
And Mr. LeBlanc, what is your announcement in Mr. Gidry's case on the trial docket?
Judge, it's still a trial.
So you ready?
Not quite, Judge. I have a deadline this evening. If I can be ready if the court requires me to, but
well, you said you're on the trial docket for 1:30.
yes, Judge, I'll be back up there if I need, if the court
Okay.
requests me to.
State, what's your announcement?
It was my understanding from Mr. Hubel, he left out the defense was gonna be requesting a continuance, which he had no objection. Can I confirm with him whether he's an LC raise or your?
Okay. Okay, so we'll see you back at 1:30. We'll see y'all at 1:30 this afternoon, set for trial. Okay.
Thank you, Judge.
Okay, you're welcome. Bernice Wilson? This is cause number 23 CCCR 2386, case of style of the state of Texas versus Bernice Elton Wilson Jr. Mr. Wilson, is that your full name? Mr. Wilson, would you please raise your right hand? Mr. Wilson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sorry.
Mr. Wilson, you may put your hand down. Again, Mr. Wilson, how are you doing?
Good.
That's good. Mr. Wilson, you're representing case by your attorney, Attorney Ben Jeffers. Attorney Jeffers is not here. Standing in for Mr. Jeffers is Attorney Tom Kelly. Does Mr. Kelly have your permission to stand in for Mr. Jeffers?
Sir.
And Mr. Kelly, do you waive a record in Mr. Wilson's case?
Yes, we waive record before we're reading, Judge.
Okay, Mr. Wilson, I have before me a document that's titled information sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Barnes Elton Wilson, on about October 10th of 2023, while you were in Jefferson County, Texas, that you committed the class A misdemeanor offense of deadly conduct. You understand what you've been charged with?
Yes, sir.
To this charge, how do you plead guilty? Not guilty, no contest.
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
And Mr. Wilson also have before me a document that's titled misdemeanor plea admonishments. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials on the line next to the box that said guilty. You place your initials on this document.
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Sir.
And on the next document, it's titled trial court certification of defendant's right of appeal. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled discovery certification. You recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Wilson, before you signed and initialed these documents, did your attorney go over these documents with you? And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge? Ms. Wilson, are you a citizen of the United States? State,
No objection, since when?
no objection, states exhibit number 1 will be admitted. And Mr. Kelly, you've advised and counseled Mr. Wilson. Is there any evidence that he is currently mentally incompetent to stand trial?
No, there's not.
And Mr. Wilson, your attorney, Mr. Kelly has advised and counseled you. Are you satisfied with his services?
I am.
Has he provided full, effective, and competent legal representation? And your attorney, Benjamin Jeffers, has advised and counseled you. Are you satisfied with his services?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Wilson, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offered 180 days probated over 1 year, $500 fine, 60 hours community service. Defendants have no contact with the victim, Mackenzie Zeno, and the defendants also agreed not to possess any firearms for the terms of probation.
That's not on the.
I think that is. Defendant agreed not to something.
No, you said, but no contact with someone too, right? Oh, no contact. I didn't see that on there.
The no contact, yeah, they didn't write it on here.
Who is it? No contact.
Mackenzie Zeno.
Here you go, you're gonna have to, somebody gonna have to write it.
So Zeno?
Mackenzie Zeno. That's the notes
Zeno.
that Andrew has.
Is, and the first name is spelled Makenzie, and Zeno is Zeno.
Okay, spell that first name again.
Makenne. No. Makenzzie. Okay. And the firearms, well, how was worded?
How was it worded, Your Honor?
Yeah.
Defendant agrees not to possess any firearms for the terms of probation, term of probation.
Was Mr. Jeffries appointed in this case?
No, Judge.
He wasn't? Okay. What's the court cost? Okay. Mr. Wilson, the state is offering you to serve 180 days in Jefferson County Jail, but you would not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $99 a month. Will you be able to pay the $99 each month?
Yes, sir.
You'll also be required to perform 60 hours of community service. You cannot have any contact with the complaining witness, Mackenzie Zeno, and you agree not to possess any firearms during your probation, and you will adhere to the other standard terms and conditions of your probation. Do you understand the state's offer and the agreement?
Sure.
And do you think that is fair and just?
Sure.
And do you accept it?
Sir.
Okay, Mr. Wilson, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Wilson, please stand next to the bailiff, follow her directions. Once you finish following her directions, you're free to go, and you have a blessed day.
Needs
And
to be
Mr.
released from this ankle monitor, Judge.
Oh, give me one of those, forms. He's the GPS. It's the same thing. Is it here? Is it this one? Okay, this is it right here. Okay, this is Wilson, Bernice. Wilson. Okay, Mr. Wilson, I just signed the motion to remove the global positioning monitoring system. You can get a copy of this order from our court coordinator. And once you finish out following the direction of the bailiff, we get a copy of the order. You're free to go, and you have a blessed day.
Thanks, Judge.
Okay. This is right. We have Mr. Wilkerson.
There's one that we're announcing ready on for Brian.
Okay.
Who on Kimler?
Yeah, there's one. I know he has a plea, but on over. We are announcing that.
Okay, which one is that? Is that Oberg? Oderberg?
Yes, sir.
Logan Oderberg? Okay, this is cause number 24CCCR 1826, case of style of state of Texas versus Roland Odelberg. Mr. Odelberg, is that your full name? Okay, how are you doing, Mr. Odelberg? I'm doing fine, thanks for asking. Mr. Odelberg, you represented by your attorney Ralph Kimmler. And Mr. Kimmler, how are you doing?
Very well, Your Honor. Judge Stevens is going to do it.
Okay, Mr. Odelberg, Mr. Kimmler, what is your announcement in Mr. Odelberg's case?
We're ready.
State?
State's ready, Your Honor.
Okay, so we'll see y'all at 1:30.
Be back one thing.
Pick a jury.
Only 35 minutes. Yeah, Miss Garrett's on the trial docket, that's a plea.
That's
Okay.
correct. We should have two more plates.
Okay, so. This we just, okay,
And, Chrissy Coffin's client came in to want to be the bond forfeiture.
Jamari and Stoker. Now, Ms. Stoker,
Yes, sir.
I have before me a document that is titled. Now you was previously sworn in, is that correct?
Yes, sir.
Okay, now, Ms. Stoker, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendants?
Yes, sir.
And are these your initials on the line that state you would like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Ms. Stoker, before you signed and initialed these documents, did your attorney, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Okay, Ms. Stoker. I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Mark Fagger. Attorney Fagger will be given information to contact you. You will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day.
Thank you, sir.
All right, please have a seat and wait for your name to be called.
Thanks. Mr. Kimmler will be sitting in for Mr. Wilkerson.
There you go. That's Mr. Stoker's. Mr. Stoker's. So he's gonna stand there, okay.
Rating those.
Who is Isabel Maria Ventura?
Yeah.
Okay.
Thanks, right. Appreciate it.
Okay, this is cause number 25 CCCR 0098, 96. The case is styled the state of Texas versus Isabel Marie Ventura. Miss Ventura, is that your full name? Miss Ventura, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
You may put your hand down. How are you doing, Miss Ventura? I'm doing fine, thanks for asking. Now, Miss Ventura, you're represented in your case by your attorney, Attorney Marcus Wilkerson. Mr. Wilkerson, how are you doing?
I'm well, Judge, thanks.
And Mr. Wilkerson, do you waive a record in Miss Ventura's case?
We do, Your Honor, and there's no issues of the competency.
Okay. Now, Miss Ventura, your attorney, Mr. Wilkerson, has advised, well, your attorney, Ms. Wilkerson, has waived the record in this case, and I have before me a document that is titled misdemeanor plea admonishment. Well, actually, this document is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Isabel Marie Ventura, on or about November 27th of 2024, while you were in Jefferson County, Texas, that you committed to Class B misdemeanor offense of interfering with public duties. Ms. Ventura, do you understand what you have been charged with? And to this charge, Ms. Ventura, how do you plead? Guilty, not guilty, or no contest?
No.
Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Ventura, I also have before me a document that is titled misdemeanor plea admonishments. You recognize this document? On page 2 of this same document, there's a set of initials IV on the line next to a box that's checked no contingent, which means no contest. You place your initials on this document.
Yes.
On page 3 of this same document, there's a signature above the line that is titled defendant. And do you remember signing that document? Now, on the next document that's titled trial court certification, the defendant's right of appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled discovery certification. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant? Now, Ms. Ventura, before you sign and initial all of these documents that I just showed you, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge? Ms. Ventura, are you a citizen of the United States?
They don't say so.
Any objections? No objection. States exhibit number 1 will be admitted. And Ms. Wilkerson, you have advising counsel, Ms. Ventura. Is there any evidence that she is currently mentally incompetent to stand trial?
None for her, Your Honor.
And Ms. Ventura, your attorney, Mr. Wilkerson, as advising counsel, are you satisfied with his services?
Yes.
Ms. Ventura, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. And I will also find that the plea and waivers was freely and voluntarily given. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The state's offering 1 year deferred probation, $200 fine, 40 hours community servicing for cost.
Okay. Mr. Wilkerson, were you appointed in this case?
I was, Your Honor.
Sorry.
Okay. What's the court cost?
77. No.
Okay, Miss Ventura, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you're required to pay a fine of $200. Those court costs are $277. You'll be required to pay a probation fee of $6 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll be required to reimburse Jefferson County court-appointed attorney's fees of $350. Your total monthly installments, that is the total amount that you will be required to pay each month, is $158 a month. Will you be able to pay the $158 each month? You'll also be required to perform 40 hours of community service, and you will be required to adhere to the other standard terms and conditions of this probation. Ms. Ventura, do you understand the state's offer? Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer? Ms. Ventura, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Ventura, if you successfully complete this probationary period, this case will be dismissed. It will not result in conviction on your record, and you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Ms. Ventura, please stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Thank you, Your Honor. Be excused.
Yes, you may be excused.
Appreciate that.
Yeah. He's supposed to put his whole name on here. The Rebus. Yeah, he just had Rebus on here. Oh.
So you know who it was.
Oh. Okay, well. His name is Juan Rivas, is it?
Yeah.
Mr. Rivas, would you please come forward? Mr. Rivas, would you please raise your right hand? Mr. Rivas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
You may put your hand down, Mr. Rivas. Let me see this paperwork. Mr. Rivas, I have before me 2 documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature on the line as titled defendant?
Yes.
Are these your initials on the line that state you would like to apply for court-appointed attorney? I also have another document that is titled Affidavit of Indigence. You recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Rivas, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Rivas, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get the information, you'll be free to go, and you have a blessed day. Please have a seat in that chair and wait for your name to be called.
Yes, Your Honor. Thank you, too.
You're welcome. Lakeisha Deanna Garrett. Here you go.
Just all caps.
Okay.
They got it in there.
Case, the court is in session in cause number 2360 Ciara 1793. Case is filed in the state of Texas versus Lakeisha Deanna Garrett. Ms. Garrett, is that your full name? Ms. Garrett, would you please raise your right hand? Ms. Garrett, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Ms. Garrett, you may put your hand down. How are you doing, Ms. Garrett? I'm doing fine. Thanks for asking. Ms. Garrett, you're represented in the case by your attorney, Attorney Ralph Kimmler. Attorney Kimmler, do you waive a record in Ms. Garrett's case?
So,
Ms. Garrett, I have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Ms. Garrett, it alleges that you, Lakeisha Deanna Garrett, on or about December 4th of 2022, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Ms. Garrett, you understand what you've been charged with?
Yeah.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Trying to get this thing. Now, Ms. Garrett, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that says check guilty. Did you place your initials on this document?
Yes, sir.
And on page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature? And on the next document, there's titled trial court certification of the defendant's right of appeal. Do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there's one box that's checked, but there's two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that? Second box check states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement? I also have a document on paper that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled defendant? Now, Ms. Garrett, before you sign and initial all of these documents, did your attorney go over these documents with you?
Yeah.
Did you understand everything that he went over?
Yeah.
And is everything in these documents true and correct to the best of your knowledge? Ms. Garrett, are you a citizen of the United States? No objection, states exhibit number 1 will be admitted. And Mr. Kimmler, you have advised and counseled Ms. Garrett. Is there any evidence that she is currently mentally incompetent to stand trial?
Yes, sir.
And Ms. Garrett, your attorney, Mr. Kimmler, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Ms. Garrett, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendants, plea, the state's offering 90 days, probated over 10 months, $500 fine plus court costs, 40 hours community service, and standard DWI conviction.
Yeah, and she's advised that she has a medical condition that's not, it would preclude her from doing the community service. I advise her it's statutory, but to get with the probation officer.
Yes,
And
the
if
probation
need be,
officer.
I
have to,
can
yeah.
file a motion to address that later.
Yeah.
Okay. Just give it the probation officer. And let me know.
Okay, DWI, okay. 10 months, 500. Okay, what's the court cost in this case? Two. Yeah. 70.
You took typing? Self-taught. You still in the keyboard? Yeah.
Okay. Ms. Garrett, the state is offering that you serve 90 days in Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 10 months. During the 10-month probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You will also be required to pay a DWI conviction fine or fee of $100. You'll be required to pay a probation fee of $60 a month, your analysis fee $15 a month. And you'll be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $194 a month. Will you be able to pay the $194 each month? Yes, sir. You'll also be required to perform 40 hours of community service. You have to attend and complete a DWI education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. Ms. Garrett, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
Ms. Garrett, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Garrett, this will conclude your case. Please stand at the end of that table, follow the direction of the bailiff. Once you follow the direction of the bailiff, you're free to go. And you have a blessed day. Mr. Matuska,
Sure.
do we have, you have a plea?
No, I don't.
No.
No, I was gonna ask for one more reset so that these scores can discuss our immigration issues with immigration attorney.
Okay.
I do expect to play really on.
Oh, I got two things to put in there.
On the free trial. Page 2.
Okay, Ms. Flores Espinosa, would you please come forward?
Your Honor, we did apply for the return diversion program, but we did not accept it.
Okay. Ms. Flores Espinoza, your full name is Vidia Flores Espinoza?
Yeah.
How you doing, Ms. Espinoza?
Good, thank you. How are you?
I'm doing fine, thanks for asking. You represented your case by your attorney, Ryan Matuska. Ms. Matuska, how are you doing?
Yeah, there you go.
And Mr. Matuska, what's your announcement?
Your Honor, we're asking for one more reset. In this case, we think we can get it resolved.
Okay, give us a reset date. Okay, this case will be reset to June 16th, 2025. You're gonna get your reset. Once you get your reset from our coordinator, you're free to go. And you have a blessed day, and you can get your reset as well.
Figure. Your Honor, I think that's the last case. I think.
Yes, that's the only one I see. Yes. Oh, this thing almost went back. Okay, now Ms. Holland, your attorney was here earlier. You were scheduled to be here at 9 a.m. And you were, when your name was called at 9 a.m., you weren't here. And then the bailiff called your name again. Forgot what time that was, but it had to be around 10 something. And you actually was, I think it was 10:38. Yeah, I think it was 10:38, and you were not here. And why weren't you here?
Cause I was running a little late.
Okay, did you call anybody?
Y'all went and sent a phone call like 5 times.
Okay. State?
Given the fact that although she was late, she did make an appearance, the state would extend a recall of the forfeiture at this time, Your Honor.
Okay, now your bond was forfeited, which means that a warrant would have been issued for your arrest, but the state has recalled the bond forfeiture. So you don't have a warrant for your arrest, okay?
Yes.
Now, the next time you come to court, you need to make sure that you're here on time.
Yes, sir.
And your attorney was here looking for you. Let's give her a reset. Okay, this case will be reset June 2nd of 2025. Stay in contact with your attorney and your bondsman. You get your reset, you're free to go and you have a blessed day. Do what? Oh.
What's the number?
Neither do I. I'm not the problem with it. It's been neither. That's Jan's, right? Yeah. I think this will be up.
Oh, who took that off? I can't see. Oh, let me do this.
Andrew's not
Ms. Senegal, would you please come up to that first row? No, behind the wall. Yeah, all the way to the end. And Miss, what's that, Cara D? No, all the way to the end, down there. Ms. Senegal, that chair down there is, yeah, you'll be next to her. And you, Ms. Hall, you'll be next to Miss Cara D. And Miss Wolf, you're next to Miss Hall. Ms. Laird, you're next to Miss Wolf. Mr. Larson, you'll sit next to Ms. Laird. Ms. Montgomery, you sit next to Mr. Larson. Ms. Rich, you're gonna sit in that first row, that second chair. Yeah, right there. Dorset, you're gonna sit next to Miss Rich. Mr. Wagley, you're gonna sit next to Miss Dossett.
Respond, but I had it more clear.
That's number 12.
So I have Mr. Small coming in, number 13.
Okay, Mr. Small, you got a chair is gonna be between you and Mr. Wagley. Yeah, one chair between. And Mr. Thomas, you're gonna sit on the end right there. Lockett, now take that second row and walk all the way down to the end, sit behind Miss Senegal. Ms. Crutchfield, you're gonna follow Mr. Lockett.
Bowman, 18.
Mr. Goolsby, you will follow Miss Crutchfield, sit next to her. Mr. Bowman, you're gonna sit next to Mr. Goolsby. All the way down there. Welty, you will sit next to Mr. Bozeman. Sit next to him, no seat in between. Villarreal, you're gonna sit next to Mr. Welty. So that's number 12 was a no show.
Is it here? Cause I don't got any more.
12 is a no show. And number 8 is a no show. Jawan. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court this afternoon for jury selection. You have been asked to come to serve on this case as a juror. And the case that we have before us is a criminal case. Criminal cases are divided into felonies and misdemeanors. This is a misdemeanor criminal case. Your felony cases are cases that are handled in the district court. Felony cases are normally referred to as your most serious type of offenses. Whereas your misdemeanor cases are normally referred to as your petty offense. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, your felony cases are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, and stage F felony. For persons convicted of a stage F felony, the range of punishment is minimum 6 months to a maximum of 2 years in the stage F and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony, the range of punishment is minimum, if they are convicted, life in the state penitentiary without the possibility of parole or death by lethal injection. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. The Class C misdemeanors are cases that start in the city court or the JP court. If they're found guilty in one of those courts, then they appeal their case to this court, they get a whole new trial. Now, the range of punishment is the same, and it is by fine only, and the fine cannot exceed $500. Now, your Class C misdemeanors are normally traffic offenses like not wearing your seatbelt or speeding, etc. The Class B misdemeanors, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine that does not exceed $2,000, or a person can be given both such fine and confinement. The highest misdemeanor is a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you have been asked to come here this afternoon for inclusion in this criminal case. Our courtroom hours normally vary from 9 a.m. to 5 p.m. However, because we have large dockets in this court, we usually have our dockets in the morning. And like today, we usually finish kind of late. We didn't finish with this docket. We had a jury trial docket, a pre-trial conference docket, and an announcement docket, probably over 60-something cases this morning. And we did not finish until about 20 minutes after 1, okay, which was about 10 minutes before you were required to come here this morning. And so we have our jury trials at 1:30, from 1:30 in the afternoon to 5. And so our court hours is normally for jury trials 1:30 to 5. Now, you have been asked to come and serve on this jury, and as a juror, you are serving or performing a significant service that only free people can perform. If you're selected in this case, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on this jury, unless otherwise instructed, you will be permitted to separate at recess, for meals, and at night. Now, at this time, I must perform the first of 2 administrative functions. The first function, or the first duty that I must perform, is to administer to you, the panel, the oath. So at this time, I need each and every one of you to raise your right hand. And then once I finish in administering the oath to you, please say I do. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions concerning your service qualifications as a juror, so help you God? Please say I do. Okay, you may put your hands down. Now, the law requires that each of you must possess certain qualifications before you may serve as a juror in a case. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. She's one of the, she put her in her seat. She's number 12. She's over here. Okay. Now, as I mentioned to you earlier, I must first determine whether or not you possess the qualifications to serve as a juror in this criminal case. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you have been seated as a juror in this case, the case could be retried, and you may be held in contempt of court and placed in jail for up to 180 days, which is 6 months, and be given a fine up to $500. Now, the way I'm going to ask the questions, I will ask a series of questions. I do not want you to answer those questions out aloud. Just answer those questions to yourself. And then when I ask the last question, I will then ask, is there anyone disqualified under the law? And if you think that you may be disqualified under the law, I'm going to ask that you raise your hand. And for those individuals who raise their hands, we will ask them to come up before the bench one at a time. And this is the bench. So we'll ask you to come up before the bench, and you'll stand on this side because the microphones that our court reporter has, they're right here. And so she'll have earphones on. She'll be listening to everything that's being said. Now, when you come up before the bench, this will be private. So what we're saying will not be heard by none of the other members of the panel. And the reason why I say that is because not only be heard by no other member of the panel, but by anyone else, because we're currently on YouTube, and so the YouTube will be turned off. The microphone will be turned off. And then we have a noise sound device that sounds like this. And then that will be on when we ask you questions. Okay? So at this time, I will ask a series of questions. Please do not answer those questions out loud. Just answer them to yourself. And then when I ask the last question, I will ask is anyone disqualified under the law? If you think that you may be disqualified under the law, I'll ask you to raise your right hand. First question. Except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under those constitutional laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication probation for theft or any felony? Now, I always pause before I ask this question because I need you to understand that I'm required by law to ask the questions that I'm asking. And so this next question, I'm not trying to prying into your personal affairs. I'm only asking this question because we're required to ask this question by law, and the question is as follows. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a pettit juror for 6 days in the preceding 6 months, or in a county court, or 6 days in the preceding 6 months in a district court? That was the last question. Is there anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Okay. Let the record reflect that we have 2 members of the panel that have raised their hands. Let me see that. We have juror number 19 and juror number 20. Okay. Counsel, y'all please come forward. Okay, County Court at Law number 2 is back in session, and jurors number 19 and 20 are qualified. So at this,
If we may reapproach on number 19 real quick, I just want to ask a question.
do you, at this time, all members of the panel are qualified. Now we will move to exemptions. And ladies and gentlemen of the panel, I would determine if anyone who is otherwise qualified to serve as a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these exemptions apply to you and you still desire to serve as a juror in this case, just remain seated. Now, I will ask a series of questions in the same manner that I asked the questions when I was trying to determine whether or not you were qualified. Please do not answer these questions out aloud. Just answer them to yourself. And when I ask the last question, then I'll ask if anyone is, we will ask if anyone on the panel would like to claim any of the exemptions. First question. Are you over 75 years age or older? Do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled in an actual attendance at an institution of higher education? Are you an officer, employee of the Senate, the House of Representatives, or other department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the past 3 years before today? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed away from Jefferson County? That was the last question. Is there anyone here who would like to claim any of the previous mentioned exemptions? That the record, okay, we have one. Hold on a minute. Okay, as juror number 7, juror number 6. Juror number 6, Britton Colby Larson. Mr. Larson, would you please come forward? Let the record reflect that no one is claiming an exemption. We will now move to excuses. And ladies and gentlemen of the panel, on the excuses, well, I will not ask any questions. I will make 3 statements. And if any one of these 3 statements apply to you, and you would like to claim one of the mentioned excuses, just please raise your hand when I ask if anyone will be claiming an excuse. First statement is as follows. Juror may be excused for observance of a religious holiday upon the completing of an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and without the consent of the state. A juror, the last question, or the last statement rather, a juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Please raise your right hand. Let the record reflect that no one on the panel is claiming an excuse, no one is claiming an exemption, and all members of the panel are qualified at this time. Let the record reflect that the time now is 2:31 p.m. on today's date of April 28, 2025. The court is convened in the case of the state of Texas versus Welton James Everett III. Again, ladies and gentlemen of the panel, good afternoon. My name is Judge Terrence Holmes, Terrence L. Holmes. You have been summoned to come to court as a prospective juror in this misdemeanor criminal case. The defendant in this case is Mr. Welton James Everett III. He's sitting at the table in the red shirt, and he is represented by his attorney, Attorney Jansen Bailey. The state in this case is represented by Assistant Criminal District Attorneys, Attorney Andrew Hubel, who is sitting first chair.
Yes.
And, well, the Attorney Shane Hilton, who's sitting second chair. And we have Ms. Haley Simmons, who is sitting third chair. Our court reporter this afternoon is Ms. Ada Christie. She is sitting to my left. She will be taking down everything that's being said. And so speak up when you are answering or asking questions. Our bailiff in this case is Ms. Brenda Mosby. You met her earlier. The defendant stands charged by information with the Class B misdemeanor offense of driving while intoxicated. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not trying to meddle into your personal affairs, but are trying to select fair and impartial jurors to hear and decide the particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. Mr. Hubel, is the state ready?
State ready, Your Honor.
And Mr. Bailey, is the defense ready?
That's right, Your Honor.
Gentlemen, the court will give each side 30 minutes unless you need more time. And the court, I will be keeping the time. Mr. Hubel, the panel is yours.
Thank you, Judge. All right, good afternoon, everybody. Show of hands, who's happy to be here? That's what. No need to lie, but I mean, basically what we're here to do is jury selection, otherwise known as we're dire, which means, to speak the truth. So I really do want your honest answers, that's what I want, that's what defense counsel wants, because we're trying to make sure that, you're a proper juror for this case. So matter taken into account first is if you know any one of us out here. Do any of you know Judge Holmes personally? Myself, Ian Hubel. My second chair, Shane Hilton. Number 19, Mr. Welty. Do you know Mr. Hilton?
Who does?
Okay. And would that relationship make it difficult for you to be very impartial in this case? Okay, so you think that you would still be able to be very impartial? Anyone know the defense counsel, Mr. Jansen Bailey? And defendant, Mr. Wilton Everett for that. And do any of you jurors know each other? Okay. That's numbers 4 and number 6. Ms. Wolf and Mr. Larson. Okay. And I see you on the second row, but first of all, Mr. Ford, Mr. Larson had, who do you know on the panel?
That was me.
Okay, and do you mind me asking what the nature of that relationship is?
She was back home, doesn't speak.
Okay, and with that, with the fact that you two could potentially end up on the same jury affect your ability to be fair and impartial? And on the back row, I saw, was it Mr. Goolsby and Ms. Miller? And so y'all are the ones who know each other?
Yes,
All right, and what was the nature of that relationship?
we work together in recent life.
Okay, and if y'all ended up on the jury together, would y'all's relationship and work impact your ability to be fair and impartial in any way?
No, sir.
So neither of y'all feel it would?
No.
Okay. So as I was saying earlier, we use this fancy word for jury selection called the liar, means speak the truth. So what we're looking for is just your honest opinion. There are no wrong answers here. And we just need to make sure that you're the right juror for this case. We might have specific questions for you depending on your questionnaire. We're not, as Jeff said, we're not trying to pry, but we just need to make sure that you can be fair and impartial. Now, we're both going to be asking you questions, and it's important that you answer because a lot of people come into jury selection thinking that if you don't talk, you won't get picked. But that's not really how that works. It's a deselection process. We don't actually select for jurors that we want. Each side gets a certain amount of strikes, and then the first few of you that don't get struck will be our jury. So let us know as much about you as possible when we ask you these questions. Getting into your jobs as a jury, you're going to be seeing all the evidence that both sides submit in this case, whether it be through testimony or through exhibits. You'll have the ability to examine those and decide what the facts are in this case. You'll be apply the law to the facts in this case, and you get a document called the charge, which explains everything that you'll need to know about the law in that case. So these 3 things are essentially your job as a jury. Does anyone feel that they cannot do these 3 things? Okay. This is a DWI case. Do I have any volunteers for this question? Why do we have laws prohibiting an individual from operating a motor vehicle while intoxicated? Okay, start with the first row, Ms. Rich?
Safety.
Okay. Safety. And why do these laws promote safety?
You have someone who's intoxicated, they sometimes can't see the road well, and it can impact not only their health and their safety, but people that.
So you're concerned with the accident, essentially. Great, thank you very much, Ms. Rich. Juror number 20?
Awareness. The fact that lives matter on both sides and the impact that it could have on families or just anybody in this surrounding, so the awareness and safety, as she said.
Okay. And juror number 20, Ms. Villarreal, would you agree with me that it's also important that these laws exist so that individuals who are guilty of this conduct are held accountable for their actions? Okay. Does anyone have anything different from what Ms. Rich or Ms. Villarreal answered? And thank you very much, both of you. So, going off of what Ms. Villarreal was saying, that lives matter, and lives can be easily taken away with someone who's operating a vehicle while intoxicated. Has anyone here suffered personal impact from the DWI or intox assault or manslaughter? And that's good. I'm glad I'm not seeing any hands right now. Flipping that question kind of, does anyone know someone or has personally been accused of DWI? All right, starting with you first, Ms. Hall, would you mind elaborating? And if you don't want to elaborate, you don't have to. We can speak later outside the presence of your new best friends. So
I'd rather speak later.
okay. Same question to you, juror number 19.
Yeah,
Okay. And given that experience, do you think you could be fair and impartial as a juror in the DWI case? Okay. In juror number 19, hearing the concerns that you heard from jurors number 19 and number 20, do you agree with those? Yes. All right. So here's the law around during DWI. This is the statute. The person commits an offense if the person is intoxicated while operating a motor vehicle in a public place. So based on that, the state would have to prove in this case that in Jefferson County, the defendant, well, Everett III, on or above a certain date, operated a motor vehicle in a public place. Well, it said the defendant was intoxicated. So looking at these elements, what comes to your mind whenever you hear the word operation? I'm sorry, who was that?
Me.
Okay, so you said mechanical, like, and that's juror number 10, Ms. Bissett. And in regards to a motor vehicle, what do you consider operation of that motor vehicle?
In the drive on the road.
Okay, so you would consider driving operation. That's correct? Okay. what if the, what if the vehicle is not in motion, but you had the key in the ignition and the engine was going? Would that be operation in your mind?
Okay, I'll be wrong, I don't know, you know,
And then-
and
and that's-
that I'd say no.
Okay, and that's really what we're asking for here. Like I said, no wrong answers. We just want your honest opinion.
We're be moving, so no.
Okay. So does anyone agree with, juror number 10? Okay, can I see a show of hands? Alright. So a lot of you, want, need proof of driving as opposed to just the engine. Okay. So public place is, kind of self-explanatory. It's any place that's open to a substantial amount of public. That's your roads, like public roads, highways, parking lots, stuff like that. Now, the big ticket issue when it comes to DWIs, as you might imagine, is intoxication, whether the driver was intoxicated. I have not gotten to speak to you yet, Ms. Senegal. Juror number 1, what do you think? Can you always tell when someone's intoxicated if you're interacting with them?
Yes.
Okay. And what signs would you look for in a person who is intoxicated? Okay, so they're slurring, maybe they're not like quite all there. Okay. Juror number 2, Miss Giardino, am I pronouncing that correctly? Correct. All right, Miss Corregia. What signs would you look for?
This personality change, I haven't really been around other than complicated people. So I would say for the ones I have been, their personality changes. And I guess they're more, I guess a lot of people are more like nervous. And then whenever, for people I know, they're more nervous. And then whenever they're more open, free, they don't really
So
think of what they're
it kind
doing.
of turns off their inhibitions?
Yes.
Okay. Juror number 3, Ms. Hall. Would you believe that the definition of intoxication requires someone to be drunk?
Pretty drunk?
Yeah.
No.
Okay, and can you elaborate on why you think that?
It's just about their ability to. You can be not completely drunk, but still not able to have all your functions, you know.
You might, you might still have, even if your BAC is low, you might still have diminished faculties. Okay. And juror number 4, Ms. Wolf, do you believe that alcohol affects everyone the same way?
Okay.
And can you give me an example of what you would say?
Height, weight, how much they drink, all of them.
Okay.
Affect people.
So let's look at this. Just since I'm gonna skip ahead since you brought up a good one. Now I'm gonna stick with you. We have 2 people. We have Larry, he's skinny. He's never drank in his life. And he's exhibiting slurred speech and a lack of balance. His BAC is less than a 0.08. Do you think that Larry's intoxicated?
For Larry, yeah.
Okay. And what does everyone agree? Or does anyone disagree with that?
Because Larry didn't drink.
Well, I mean, that'd be a fact question, but going off of what I've told you so far, would you believe that he's intoxicated? And just for the hypothetical, he has been drinking alcohol. So, what would your answer be? Number 10 is this up?
More information.
Okay.
Because I know, like, I mean, somebody can have, a TIA and slurred speech and.
Okay. And juror number 7, Ms. Montgomery, you have your hand raised.
I was going to say what she said, it could be something medical going on, diabetes, a stroke.
Okay. So you would essentially need more. All right. And then we have, I'm gonna come back to you again, as well, our criminal justice teacher. So we have, Robert, he's a bigger guy, he's a career drinker, he can handle the alcohol very well. He does not present the same way that Larry did, he does not have slurred speech or, lack of balance, but at time of testing, his blood is higher than 8.08 BAC. Would you believe he's intoxicated?
Over a point of eight.
Yep.
Okay.
And does anyone disagree with that? Anyone's in agreement? All right. Now, this example right here is precisely why we have 3 cases of intoxication. And those 3 are loss of mental or physical faculties, that's 2 of them, by the introduction of alcohol, some drugs, some other substance, or a combination thereof. Or you have a BAC of 0.08 or more, an alcohol concentration of 0.08 or more. So for mental faculties, let's see, Ms. Laird, juror number 5. What would you identify as a lack of the normal use of mental faculties in someone? I'm sorry, I didn't hear that.
No, I'm just saying what you said. Can you say that again?
Whenever you're looking at someone, what would signal you to a lack of mental faculty or loss of the normal use of their mental faculties based on the introduction of alcohol or some other substance? Okay. All right. Juror number 6, Mr. Larson, do you have any thoughts on that one?
Let's say, not be able to answer questions correctly, sort of problems in reasoning. So at that point, I guess they're going to go to somebody who asks questions as they can to the signs there.
Okay, great. So you would say, like, if someone's confused, if they're not answering questions correctly. What about memory loss?
That could be the phone, but it's not necessarily exactly telling. Really effective.
But if that existed in combination with some evidence that the defendant was taking a substance, with that in your mind?
Other DNA evidence.
Okay. No. Now, for physical faculties, Ms. Montgomery, can you give some examples?
Unstable balance. Shaking.
Okay. Can you think of something maybe with, like if their physical appearance, so anything change?
Her clothes may be disheveled.
So, Ms. Rich, you've already helped me out earlier today. Can you help me by, finding any other signs of physical faculties? Or rather, lack of physical faculties, by the introduction of alcohol?
I know like when they do the sobriety test or whatever, they have to do the fall to light, but they can't follow
Okay. Have you ever seen someone with red bloodshot eyes, in regards to alcohol? Now I see juror number 12, Ms. Woodson, nodding your head. Will you? Okay. All right. Any other signs that you can think of, Ms. Woodson? And thank you all for helping me. Now this last one is pretty cut and dry. It's having a BAC of 0.08 or more. That one's just a straight number. Either it is higher than 0.08 or not. Now, your number 10, this does say, how many of these bases do you think that the state has to prove in its case?
Well, blood alcohol.
Would it surprise you if the state only had to prove one of those three?
Yeah.
Well,
No. I mean, if the blood alcohol, the way over, you know, that would be the one.
but in order to prove its case, the state only needs to prove one of those three. It could be the blood alcohol level. It could also be showing a lack of mental or physical faculties. So any one of those three, if it's satisfied in your mind as a juror beyond a reasonable doubt, then that person, then you found that person to be intoxicated. So would you personally have a problem with the state only proving one of those? Could you, more succinctly, my question is, could you follow the law if the law says that the state only has to prove one of those bases to you?
I could. I've just known I've had several drinks before and, I can maintain my balance very well.
Okay.
I mean, it wouldn't, I mean, you know what I'm saying?
Yeah, I understand what you're saying. And again, there's no wrong answers. We want your honesty.
Yeah, with college.
Okay, is there anyone else who would have an issue with the fact that the state only needs to prove one of those bases that we were talking about? Okay, that's your number 11, Mr. Wagner. So can you please explain?
Like, your mental faculties may not be there if you're nervous or some other medical condition going on. That's the only thing that to be proven, and I wouldn't be able to do that.
Right, and we would have to prove that to you beyond a reasonable doubt kind of thing. And what you described as a case where we haven't proven it to you beyond a reasonable doubt, that mental faculty is not, that mental faculty is connected to intoxication. We haven't shown you to that level.
You could prove to me that beyond a reasonable doubt, what are you doing? I can consider it.
Okay. So, did anyone else have an issue with only things? All right, thank you very much. Oh, sorry, Ms. Rita?
Yeah. For example, I have anxiety, so I get nervous fast. So just because of me being anxiety versus like people I don't know, I would be nervous versus the person I do know, I'm more open, you know, so meeting somebody for the first time or just anything new. Again, the bloodshot eye thing, it's also medically, I worked in an ophthalmology place where we have blood like vessels burst, so you don't know, you know that, so.
Right.
It's more than one thing for it to be proven.
And, yeah, and I would, ask you the same, question I posed to Mr. Wagner. Like, in the situation where we have proven to you, beyond a reasonable doubt, this is a hypothetical. That physical or mental, loss of faculties is as recalls, introduction of the substance, would you then be able to find, or would you then be able to follow the law in that regard? Okay, and if you were given a charge with the law saying that the state only has to prove one of these cases, would you be able to follow that? Okay. And again, there's no wrong, like, if you feel, actually that you could not follow that law, then, like, please answer honestly.
And what other, factors are proven.
Right. And all that evidence, the testimony and exhibits is, will be there for you to consider making a decision.
First offense, or?
That would not be something that we'd be discussing at this point. So, is there anyone here who would require the state to show evidence of blood or breath results in proving their case? Okay. And just to be clear, that was juror number 10, Ms. Bissett, and number 2, Mr. Breda. And 3, Ms. Hall. Okay. As well as number 19 and number 20. No, ma'am, that was why I was explaining those 3 bases. The 0.08 is only one of the 3, bases by which we can prove intoxication. Intoxication can be proven solely by a loss of mental or physical faculties due to the introduction of the substance as well. Does that make sense?
Where, why don't you need one more time?
Okay,
Okay.
so the 3 bases of intoxication, the first one that you know and agree with is the 0.08 BAC. The state can also prove intoxication by showing the defendant exhibited a loss of their normal use of physical faculties by the introduction of a substance, or mental faculties by the introduction of a substance. So any one of those 3, and jurors do not have to agree on which one either. You could find that he is intoxicated based on 0.08 or higher BAC. And Ms. Rich, for example, could see that he or she exhibited a loss of mental or physical faculties based on the introduction of the substance, and you would still be unanimous in finding that he's intoxicated. Just so long as you were satisfied beyond a reasonable doubt that one of those 3 bases is met, then the state was proven intoxication.
Okay, and that would be like, you would prove the substance, correct?
Right, we would have some,
Some evidence.
yeah.
Okay.
Okay, does that make sense? No, that's okay, that's what this is for, this is exactly what this is for, clearing up any confusion about those things. Is everyone else good on 3 bases? All right. And does anyone have any questions about the loss around DWI for this one? Okay, I'm not showing you. Okay, so this is what I was referring to earlier when referring to beyond reasonable doubt. It's our burden as the state to prove our case, to prove all the elements of our case beyond a reasonable doubt. Now, I'm sure you're wondering whether or not we can give you that definition. I'll turn it over to our attorney, number 14. Do we have a definition we can give you for beyond a reasonable doubt?
Yeah, definition that you can give us about what that means?
Yeah.
It means that you don't have to exclude every single thing, but anything reasonable, I guess that would be the word it turns on. Beyond a reasonable doubt, you can still have some doubt.
Yeah, and I would definitely agree with you that it's not beyond all doubt. It's not beyond a shadow of doubt. But as for a strict definition of what beyond a reasonable doubt is, we cannot give you one. It is going to be a personal standard that each and every one of you has to come to on your own. Now, defense will probably discuss like the different burdens of proof and how each individual one scales up. But this is not an impossible burden to reach. These you will be examining all the evidence on like through the testimony and exhibits in this case. And it will be up to you in your mind to decide whether or not the state is beyond the reasonable doubt. So, given that I'm talking about the state's burden, this would also be a good time to talk about the rights that the defendant has. Juror number 13, Mr. Small. Does the defendant have to testify?
No.
Right, and that's one of his rights, correct?
True.
So he has a right to trial, he has a right to remain felon, he has a right to testify or not at that trial. Would anyone hold the defendant's choice not to testify against him? Good. Another important right that defendants have. Let me ask you, juror number 15, Mr. Lockett. As we are right now, without anything being said, without any evidence being introduced or any testimony being done, if you were asked to vote guilty or not guilty in this case, or I need more info, what would your vote be at this point?
Definitely more info.
Okay, does anyone agree with that? Okay. Does anyone say not guilty? Okay,
Say innocent until proven guilty.
that's correct. That's the presumption of innocence, and that's what I was getting at. At this point, given the fact that I have not introduced any evidence, the defendant has that presumption of innocence. Each and every one of you also has that presumption of innocence. And that's what our burden is to overcome by proving our case beyond reasonable doubt. Defendant also has the right to subpoena witnesses and the right to discovery in this case, meaning that you have to give them any and all information that I have regarding the case, and that right is non-reciprocal, meaning that he does not have to give me that same information. So again, just to run through the elements really quick. In Jefferson County, defendant Malone Everett, on or about a certain date, operated a motor vehicle in a public place while said defendant was intoxicated. So my question for you, juror number 16, Ms. Crutchfield, what kind of evidence would you like to see in the DWI case?
Well, definitely, it just needs to be very clear and precise to one of those three elements.
Yes, ma'am. And what would you like to see personally? Like as far as like the types of evidence that I would enter into this case?
I'd like to see maybe some video footage if there's some physical or mental confirmation.
Okay, so
blood alcohol level.
So, but any results from a blood and breath or blood and breath test? Potentially you're talking about video, maybe the body cam or dash cam from an officer.
Very good. When it was stopped, where it all took place.
Okay, and there's one critical thing as well, testimony. And we get those through our witnesses. And juror number 17, Mr. Goldberg. What do you who do you think we would be calling to testify in a DWI case?
Anybody goes around, mostly like passengers, other officers, who's with them during the time of the incident.
Okay, so police officers, maybe those who are like passersby, maybe people who were involved in, like certain accidents as well. Will you expect to hear from, an expert? If we were to submit blood rep results, would you want to hear from an expert? Okay. And, let's see, number 18, Mr. Bowman. Talking about testimony, how do you tell whenever, you're listening to someone, whether or not their statements are truthful, whether or not they're credible?
I mean, body language, you know, if their story keeps changing. Those types of things.
Okay. And is this the kind of stuff that you use every day, just to gauge whether someone's telling the truth or not? Okay. And, yeah. And that was the constant, are you telling the truth or are you lying?
Yes.
So whenever you're evaluating that, a person's credibility, say that you just met them, where do they start? Would you say if they start like with a blank slate as far as their credibility? Yes. And will you apply that to everyone that you hear from? No, that includes officers.
Would the officer have a blank slate?
Right.
Slate when they start? Yeah.
All right. Can everyone agree with that? Because I know that there's a good amount of you who have law enforcement in your family. So no one would treat the testimony of an officer with more credibility at the start than any other witness? All right, good. So basically, this is the evidence covered, testimony, video, blood or breath test results. This is the evidence that you will have to decide the case. And there'll be this is what will help you arrive at the facts that you examine as part of your role. You were looking at the testimony exhibits, deciding the facts derived from that evidence, and then applying the law from the charging document, which will explain everything that you need about the law of DWI, and coming to a verdict in this case. Does everyone think they can do that? Y'all can all be fair and impartial. Does there anyone who cannot sit in judgment of another for any reason, whether it be philosophical or religious? All right. And do you have any questions for me at this time? Because this is the last time that we'll get to talk back and forth like this, but while the trial's going on. Jury number 20, Ms. Laura.
What makes you want to be a lawyer?
Okay, this is the cheesiest answer ever. But I kind of wanted to be a superhero as a kid. This is specifically why I chose to be a prosecutor. Why I chose to be a lawyer is because there's a lot of legal professionals in my family who really thought that I would excel in law school. And then as for why I wanted to be a prosecutor in general, because I wanted to be a superhero. I wanted to be able to fight injustices that take place in our society.
When you win your cases or when you lose your cases, how do you treat you afterwards?
Depending on the case, if I lose an assault family violence case where I believe someone's been seriously hurt, it crushes me. Like, it's one of the hardest things to take because, like, at that point, if that happens, you have to talk to that victim. It's one of the hardest things in the world.
So would you say that you would stay slumped in that area for feeling bad for quite a while, or will you be able to overcome that and just you can't win them all type of thing? Like, I mean, stay in mind afterwards.
You kind of have to keep going, otherwise, like, then they can get back to you. But do you have any other questions? Anyone else have any questions? All right, thank you very much. Both the state and the defense appreciate that you're here, but this process could not work without you. And I look forward to presenting that case to whichever state selectee wants to pick.
Okay, Mr. Bailey, the state took 39 minutes, you have 39 minutes.
Thank you, Your Honor. Good afternoon. Thank you all for being here. My name is Jansen Bailey. I'm from Beaumont, with Beaumont Westbrook. Went to Texas A&M, then went to University of Houston, and went to law school at South Texas College of Law. I am 40 years old this week. My client is also my friend. He and I have known each other for 25 years. I played basketball in high school. Actually, my alma mater just won state this year, so I went to Westbrook. And we call him Jody. Jody and I played basketball against one another in high school. So I've known him for a long time. We're here today to, as right now, jury selection is really deselection. The truth is, the more you talk, the less likely you'll stick around and stay on the jury. So we go down 1 through 20, and we get a certain amount of strikes, and there's a lot of legal stuff that goes behind that. But the more you talk, the more likelihood you're going to give one of us a reason not to strike you. So if you want to go home, speak up. So the reason why we ask questions, so there's implied biases. Everyone due to our life experiences have certain kind of bias, right? And so that means that for certain cases, some people aren't, probably the best juror for a certain case. For instance, if this was a burglary of a habitation case and your home got broke into last night, you might just not be the right person for this case. You might, but you might not be. And so that's why we go down and ask kind of a list of questions. This is the only time throughout the pendency of the case that I'll ever be able to interact with you one-on-one or as a group. So if you have questions of any kind, ask them, because I won't be able to answer them after the next 39 minutes or so. This is a driving while intoxicated case. That's what my client's been alleged to have done. As he sits here today, he is innocent. The defendant has no burden to ever even put on one piece of evidence. That's why the state goes first. The state goes first, they present all the evidence that they have. And the defendant doesn't have, we can cross-examine the witnesses, but we have no obligation to put on one piece of evidence. Not to call one witness, not to have one expert, not to have one testify. In fact, Mr. Everett does not have to testify in this case. Now, I know the state asked it earlier, but would any of you hold that against him if he chose to not testify in his own case?
Testify means like speak up.
Like he would take the stand and be asked questions. Now, there's a reason why that most defendants don't testify. And that's more of like an understanding between the attorney and the client, but there's a lot of legal ramifications that you do. And so that's why sometimes defendants elect to not testify. Now, he might not testify, and it might be because I tell him not to. It might not be because he might want to, and I'll say, hey, listen, I think it's in your best interest not to. So in any event, you can't hold that against Jody. And if you would hold that against him, I need to know, because that means that you're not able to follow that. So as he sits here today, yes, please.
Is it harder to, I don't know how to say it. Is it harder to, if you can't answer it, it's fine, I get it. Is it harder to come up with a conclusion if they can't testify?
So that's something that you have to evaluate, but you can't take into account him if he does not testify, you just can't use it against him.
Yeah.
Does that make sense?
Yes.
And remember, the state has the burden to present all the evidence in the case against him, because he is a citizen of the US, right? He has certain freedoms and constitutional rights. One of those is the right, life, liberty, and the pursuit of happiness, right? And so if the state is going to bring a case against him and charge him with the allegation that he committed a crime, It could have ramifications financially on his liberty, on his freedom. Then the state should be the one to have to present all the evidence that they allege that the crime that he did. So that's why he's presumed innocent. As he sits here today, he's presumed innocent. And if anyone has an issue with that, I would ask that you raise your hand. Miss Wolf, how did you get into teaching criminal defense or criminal justice?
I have my master's degree in criminology and then a past work experience in the world of criminal justice.
Okay, and so what do you currently do?
I teach criminal justice at New High School.
Okay, and that's where I take it that, is it Britain? That, so you went to Nero High School? I just thought it was so ironic that in a world, you might actually sit on the same jury. And that's just really interesting to me. Yes. What does he coach?
Football. He's the new head coach.
That's a big job.
Yes. So we just moved to New England.
Where are you from?
Katie.
Okay, so, but which one, which Katie High School?
Katie High School.
That powerhouse Katie High School.
Uh-huh.
Yeah.
Haven't won a state title since 2021. I was an option there and I got a ring, but we're trying to see what they're gonna do.
Really? Well, I wish future success to your father. I'm not in the PNG Nearland debate. I went to Westbrook, but I know that's kind of a big thing.
It's a big deal.
It is. So the state has a burden. So in a civil case, when people are arguing over money, the burden it's called by preponderance of the evidence. So it's like 51-49, like just a little bit over. That's all you have to prove in order to win in a civil case. In a family court, when someone is having their children potentially taken away from them, the evidence has to be clear and convincing. So that's the next level, that's the next burden. And above that, which is the highest burden in our country, in our constitution, the highest burden in our land, is beyond a reasonable doubt. That is the burden that the state has in order to convict a citizen of the United States of any crime. And so if the state is going to allege it, they have to prove each and every element. So there were what, 5 or 6 elements to the DWI, and you'll see it again. Oh, and by the way, the judge is the one who's going to supply the law. Your job is to observe the facts, the credibility of witnesses, and then apply that law, those facts to the law and come up with your determination. So we can go through and break down elements and ask you about this or that or the other. The reality of it is, in the charge, which is going to be supplied by the court, which he and I are going to argue over behind closed doors, is going to be what is your instrument, what's going to show you, instruct you about what to do. So if you're a little bit confused about the law, as it was presented earlier, don't worry about it. The judge is going to be the one who's going to supply that document. And so I wanted to kind of go over that when he was going through each and every element. Now, has anyone here been charged? Well, has anyone here had a family member that's been charged with a DWI or was involved in someone in a wreck that was a result of a DWI? Has anyone been hit by a truck? Okay, and we got that. Has anyone had a family member who was hit by someone who was alleged to have committed DWI? Is it Miss Woodson? Who in your family? Okay, and what was the outcome? He died. I'm sorry to hear that. And you know what happened to the person who ran into him? Okay. And how long ago was that? I'm sorry for your loss. Has anyone else had an unfortunate experience with Ms. Woodson? Is anyone here, let's talk about organizations which are a part of this. Is anyone here a part of MAD? Does anyone in here know what MAD is? Exactly. Is anyone here a part of that organization? Yeah. Is anyone here a part of that organization? Okay. Has And I could go down and ask each and every one of you, and I will if we don't start talking, because that's the point of this. You know, and so has anyone, has, so, has anyone here been charged with, or been a part of, has anyone here ever sent a jury report? Okay, let's go. Let's start down the line. Is it Miss Hall? What kind of case?
One was murder and one was.
Okay, and you were a juror on both of those? And what was the outcome of the murder case? Convicted, and what was the outcome of the DWI trial? Okay. Who were the next jurors? Okay, Miss Wolf? Okay, and what was the outcome? Okay. Thank you, guys show up. Miss, is it Montgomery? What case? What kind of case?
Capital murder
Ooh.
involving a police officer.
Oh, gosh. What was the outcome?
He was convicted.
What county was that in? This county? Do you remember the lawyers?
No, it was like.
Okay. Who's next? Mr. Small. Okay, and what was the outcome? Okay, I got a whole bunch of people finding guilty on this panel. And to my lawyer, what kind of case?
Murder. He got on the stand against his attorney's advice, confessed and found guilty.
How long ago was that?
30 years ago.
Okay. And so what law do you practice?
I'm across the hall on the civil side with ponderance of the evidence.
And what firm do you work for or work with?
Right now, I do property tax collections for Linebarger, but for the last 33 years, I was doing mass torts, personal injury with Brent Coon.
Yeah.
And a little off the back of the brain. They still have me in their commercials sometimes.
I was like, I've seen that face before. Well, it's nice to meet you. So to get back to it, the state has the highest burden in our country. So each and every element, and the judge was going to give you the law, has to be found beyond a reasonable doubt. They have to prove it. So they're going to have to, for every single one of those things, they're going to have to, prove each element beyond reasonable doubt. Now, I believe the only one that we're going to really fight over is the intoxication element. And so that'll probably be where you hear most of the evidence. I assume that where most of the evidence, the point that it will be about. There are going to be, I'm assuming, one or more police officers testifying as witnesses. I don't call the witnesses, but the state has the burden to, but I believe there will be at least one, if not more. And when it comes to the credibility of a witness's testimony, we all should start, and he was the state's attorney was alluding to it earlier, that you can't give a police officer more credit than anyone else, because at the end of the day, that badge, he should not garner more power as a witness than someone who does not. We aren't judging their job titles, we're judging their credibility. So it's as to what they observed and as to what they speak. And so that's the way that you're going to evaluate the credibility of a witness. Now, each and all of us have like a different internal mechanism that says, I don't know if that person's telling the truth or not. Now that's up to you, but you need to apply that to what everyone else, to the testimony that you hear at the stand or on the stand or from the stand. Who would require who here would require only blood or breath evidence in order to find conviction? Who here require, you would have to have that in order for me to find that person guilty?
Those are the only two things that you would present.
I know, of all the things, but I'm saying, who would have to have that? Would anyone here have to have that, some type of element of scientific evidence, being the breath or the blood, in order to find that person guilty? So weeks 3, 4, 5, 9, 10, 12, and 20. Now, when we ask, can you apply the laws to the facts? Or would you have a problem applying the laws to the facts if the law said that you didn't, that was not required? The law said that you did not need to have that evidence to find someone guilty. Would you be able to follow the law? Or would that be a problem for you? Would you require, regardless, that person, that evidence have to be evident in order for you to find him guilty? So 20. I know, half the time we get confused talking about it. Isn't this Rich? Was there anyone else down there that you would require that evidence in order to find the person guilty?
I know, that's pretty bad. I mean, wouldn't that just, I mean.
I'm not,
Okay.
yes, so.
So
Okay.
what you're just saying, like, if they say that the law, said you don't have to have evidence, but you're like, well, if I'm gonna be judging something, I need the evidence.
That's what I'm asking.
Something that's gonna help me fall on yes or no.
Yes,
So I need, evidence.
okay.
Yes.
What if there's other evidence and that's the only evidence that you don't have?
I mean, it depends on what it is.
Okay.
I'm with her.
Hold on, I gotta get all this down.
The charity, it's not gonna be these, is it?
No, it'll be these. Which are a little bit more comfortable, they have a little swivel to them, so. And the judge is usually good about giving breaks. Are there any questions that I haven't answered? I'm sure there are. Are there any questions that you guys have for me? Remember, this is the last time that I'm gonna be able to speak with you. The judge is gonna instruct you, whoever gets deselected and put up there, that we are not to speak when we cross paths. We're basically not gonna even look at one another. So if you see me kind of putting my head down, it's not that I don't want to make eye contact with you. It's that I don't want to do anything that would be improper. Yes, ma'am.
So you said y'all were friends, y'all been friends for a long time. So, what made you decide to want to represent him, even though, cause it's his for pleasure, you know what I mean? It's like that. So, I mean, even the fact that he's your friend, but what made you want to be a lawyer?
So I'm worried that you're gonna ask this question. So I have an interesting background. So the reason why I became a lawyer kind of has a little traumatic component to it. So I'm a twin, and my twin brother's name is Jonathan Bailey. And when we were celebrating our 22nd birthday, his life was taken from him by someone else without cause. So my twin brother was murdered. And 3 years later, we went to court and the person was found not guilty. And I didn't understand why it's, how something so obviously right could end up so obviously wrong. And how someone could not pay for what they've done. And so I had my mother and my brothers, and they asked me, why? I didn't understand why. So I went to law school to figure it out. That's why I became a lawyer. And I was a prosecutor after I went to law school. I did that for a year and a half. I did exactly his job in the courtroom next door. And so, as to Jody and I, why am I defending him? Because he's my friend. And because after reviewing it, can't really talk about the specifics of the case, because that'd be improper, but there's a reason why we're in trial. The only cases that typically go to trial are the cases that are somewhat in the gray area. The cases that are obviously this, typically go, or obviously that, typically go that way. It's the cases that are in the gray area, the ones that get to be tried. And so we're sitting here today in judgment of an innocent person, and I'm gonna do my very best to defend it because I think that's the right thing to do. Good question. Anyone else have a question? Yes, ma'am.
Why did you switch from prosecutor to defender?
So that's also a good question. So I started, one of the things I figured out when I was in law school that I was better at, or what I enjoyed more, was standing up in front of people, like trial or being a trial lawyer. And I just really enjoyed that. And the reason why I started out as a prosecutor was when I came out of law school, there were no jobs. And I needed a job. And I needed a job that would allow me the ability to be in trial as often as possible so I could get better and better and better at what I was hoping to do. And so that's the job, the most the best opportunity to try and case after case after case after case is being a prosecutor in the district attorney's office. So I wanted to get as much experience, and it was better to do that most efficiently than to go and work for someone else. And our attorney can attest, there's not a lot of cases when you're a civil lawyer to go to trial. And so if you want to get that experience, you typically hop in the DA's office and then do, some amount of time doing that, and then you go into your own practice. So that's what I've done. So yeah.
Your mom, Darn,
That is my mother. How do you know my mother? Did you? Is the magistrate brother, the sort of magistrate brother? How do you know my mother?
From Sally Curtis years ago.
My mother is a single parent. My mom's single with 5 boys. I'm one of 5. And have a phenomenal parent. She is now retired. She's 72, and she was a special ed. Well, she was a diagnostician forever, and then she went to be a special ed director. And so, yeah. So Diana Bailey's mom. Does anyone else in here know Diana Bailey? No. Any other questions? All right. Well, thank you so much for being here. This isn't going to be like some, court TV where there's going to be all this, evidence and all these, cool electronics, it's not going to be like that. So I hate to burst everyone's bubble, but this isn't going to be like what you see on TV. I still hope that you're engaged and that you enjoy it, and that you, that you come to the right outcome. So thank you.
Okay, thank you, Mr. Bailey, and thank you, Mr. Hubel. Ladies and gentlemen, at this time, we will ask that you follow, or you can go out either one of the doors, go out into the hallway, and then we're going to call some of you back into court for some follow-up questions. So at this time, everyone please stand as the panel exit the jury.
I'll be on the other side of that wall.
Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M333-482, case of style of state of Texas versus Walton James Everett. Let the record reflect that Mr. Everett is present in court with his attorney, Attorney Jansen Bailey. Let the record also reflect that the state is present with Assistant District Attorneys, Attorney Andrew Hubel, Attorney Shane Hilton, and Attorney Haley Simmons. State, are you ready?
State for your honor.
Defense, are you ready?
Difference is very young.
Ms. Mosby, you could bring in the panel and tell them to sit where they were sitting. Oh, she needs to put that up there. Yeah, everyone, please stand. Okay, you may be seated. Let the record reflect that the court is back in session and calls number M333-482, case of style state of Texas versus Walton James Everett III. Let the record reflect that Mr. Everett is present in court with his attorney, Attorney Jansen Bailey. State is present with Assistant Criminal District Attorney, Attorney Andrew Hubel, Attorney Shane Hilton, and Attorney Haley Simmons. Let the record also reflect that the panel is now present and seated in the courtroom. Okay, ladies and gentlemen of the panel, when your name is called, please go and have a seat in the jury box. There are some badges that are on the top counter. You can take a badge and pin it to yourself. At this time, we'll be in the hands of one of our court coordinators, Ms. Trina Redmond. Ms. Redmond is going to call your name. Ms. Redmond?
Yvette Senegal.
Senegal? You can get a badge.
Andrina Hall. Britton Larson. Donald Small. Ron Thomas. This Lockett. Sasha Villa Real.
You need to get a badge. Make sure you pin those badges on. Ladies and gentlemen of the panel of the jury, at this time, I need to administer to you the second of the two oaths that I previously mentioned. So at this time, I need each and every one of you to raise your right hand, and once I finish administering the oath, please say I do. Do each of you do solemnly swear or affirm that in the case of the state of Texas versus Welton James Everett III, that you will a true verdict render according to the law and the evidence, so help you God? Okay, you may put your hands down. Members of the jury, I will give you some general instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of witnesses and the way to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why testimony, a document, or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be within hearing or present when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, it would require that the court reporter leave the courtroom. She would have to gather all of her equipment. It also will require that the attorneys would have to gather their files, etc. The ruling I do make in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defense have rested their case, the court will prepare and submit to you a charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make a reasonable deduction from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt an independent investigation on your own. Don't visit the scene involved in the accident in the facts of this case. Don't read any reports in the newspaper, watch television reports, or even read anything on social media about this case. Do not make up your mind about this case until all the evidence is in and both the state and the defense have rested their cases. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or proceeding is in progress. The badges that you have, please wear those badges at all times because they identify you as a juror in this case. And you will be allowed to take those tags home with you. And so make sure that when you come back to court, make sure that you are wearing the badge every time that you come into the court House. Now, ladies and gentlemen of the panel, those of you who were not selected as a juror in this case, on behalf of the citizens of Jefferson County, and behalf of the staff here in County Court at Law Number 2 of Jefferson County, I'd like to thank you for taking time out from your busy schedules to be here today. Now, I know some of you might think that you wasted your time by coming down here and you wanted to be on a jury and you did not get picked, but I can assure you that you did not waste your time. As I mentioned to you earlier today, that the reason why we were starting at the time that we started was because our docket from 9 o'clock this morning didn't end until 1:20 this afternoon. And the reason for that is because, as I mentioned to you earlier, we had some dockets this morning. We had a trial docket. And the trial docket was individuals who were set for trial today. This was not the only case. And off that docket, several cases were moved. And when I say they were moved, this is what I'm talking about. Sometimes individuals, the state has a right to make an offer to settle the case. They made that offer months ago. And a person has a right to accept or reject that offer. If they reject the offer, then they tell the court that I want my case set for trial. And then we give them a trial date. But some individuals sometimes say that they would like to have their case set for trial because they think one or two things is going to happen. One, they think that, well, the jury is not going to show up. Two, they think that witness is not going to show up. But on days like today, when jurors show up, when citizens like you show up to serve on jury duty, they have a change of heart. Okay? And that was because of you. So you were working before you even came into the room and you did not know it. Okay? And so we like to thank you for taking time out from your busy schedules to be here this afternoon. Now, I know that also when you came to court this afternoon, you was looking for your right courtroom and you looked over the top of the door of this courtroom and you said, oh, this is Judge Holmes' courtroom. This is County Court at Law Number 2. I'm in the right place. But this is not my courtroom. I'm only a public servant serving the citizens of Jefferson County. This is the citizens of Jefferson County courtroom. So this is your courtroom. I've said that to say this. Anytime that you're in the area of County Court at Law Number 2, you can come have a seat in your courtroom. You can sit in that area that you're sitting in. We call that the peanut gallery. But it doesn't mean you could bring peanuts in here and eat because this is not the Texas Roadhouse. And so anytime you're in the area, please come have a seat in your courtroom and I can assure you that you will find what goes on in court and what goes on in Jefferson County very interesting. Now, your jury service is concluded. It's after 5 p.m. The district clerk's office is closed. Our bailiff have some letters that she's going to hand to you. Each one of you can take a letter. And if you'd like to drop us a line, you can do that. And if you need any excuses, you would have to get back in contact with the district clerk's office on tomorrow. So, ladies and gentlemen of the panel, again, I'd like to thank you for taking time out from your busy schedules to be here. This trial is going to start again at 1:30 on tomorrow. If you would like to come and have a seat in County Court at Law Number 2, your courtroom, you can have a seat in that area, or if you cannot come, if you're still interested in the case, you can watch us on YouTube. Okay, so at this time, before I let you go, I usually give all the prospective jurors a handshake. We still have COVID in our community. However, I give what I call an air handshake. So at this time, I like to give everyone an air handshake and thank you for coming here to County Court at Law Number 2. And at this time, you are excused and every one of you have a blessed day. Thank you. Y'all can be seated. Now, ladies and gentlemen of the jury, as I mentioned earlier, we will start back at 1:30 on tomorrow. And so we need everyone to come back and have a seat outside of the courtroom. And then when we're ready to start the trial, the bailiff will come and get you. And just for a brief overview of what you can expect on tomorrow. Tomorrow, we will have the presentation of the information. The information is in the misdemeanor court is what an indictment is in a felony court. That's the charges. And so the state will read off the information or present the information. The defendant will enter a plea, not guilty. And then the state and the defense will make opening statements. And then the state will start its case in chief by calling its first witness. Okay, so make sure that everyone is here on time so we can start on time. And so we'll be in recess until 1:30 tomorrow on this case. We have a docket in the morning. That's what we call arraignment, but we're going to start this case at 1:30. So at this time, you're excused for the evening. You can go out either one of the doors. That one is locked? Okay, so we'll go out this door. Yes.
Good question. How long do we estimate this trial will last?
I have no idea.
State's case in chief could end as early as tomorrow or stretch slightly in Wednesday.
Yeah, I have no idea.
So just expect to show up each day's consecutively at 1:30?
Yeah, yes, yeah. We always start at 1:30, but as I mentioned here, tomorrow we will start at 1:30, yes. Oh.
So two to 3 days.
Yeah.
3 afternoons.
Okay. So at this time, we will have everyone to please stand as the jury exit the courtroom. No, she has peanuts.
Really got peanuts.
She has peanuts. She has peanuts. No, she had a.
Hey, not.
Yeah, court being recessed in this case at 1:30 tomorrow. Defense and prosecutors
I'm
and
here to sit.
Mr. Everett, you're free to go. And y'all have a blessed day.
Right, you go.
And this will conclude the calling of call number M333-482, State of Texas versus Walton James Everett III. Court will be in recess until 1:30 tomorrow,
Yeah, that's all.
April 29th,
Care about for.
2025. Judge Terrence L. Holmes presiding.
I know what they think.